Hello. What does that matter? Second appeal. Second appeal. Second appeal on Thursday. Yes. Second appeal on Thursday. Writ petitions tomorrow. Writ petitions tomorrow. Fourth fourth ಯಾವ್ದ್ರ matters? Fourth take it tomorrow. ಆಯ್ತು 1 ಲೇಬರ್ ಮ್ಯಾಟರಾ ಕೊಡಿ. Yes.
Page number 5, serial number 26 to 29.
ಮುಕ್ಕಣಪ್ಪ ಅವರ ಮುಕ್ಕಣಪ್ಪ ಹುಷಾರಿಲ್ವಾ? ರೇಣುಕಾ ಮ್ಯಾಮ್. Yes, we'll see. At request of respondent counsel, this matter next week. 22 further hearing. Why suddenly he was unwell today? We argued the matter on Thursday. So counsel submits that Prakash M. Patil, learned counsel for the appellant, is unwell. This matter on Monday under the same caption. What is that you are giving the court? To say that counsel is not well, Counsel submits that the counsel H. Suresh is unwell and he is admitted in hospital and is admitted and he is under medication. Admitted, but he is under medication. Vapas kodi. This matter on next Monday as a final chance. Yes.
Page number 6, serial number 30 to 36. Page number 7, 37 to 42.
Monday.
Number 9, page number 8, serial number 43 to 46.
43 Monday. Shekhar ಅವ್ರಿಗೆ inform ಮಾಡಿ. Inform ಮಾಡಿ.
Page number 9, serial number 47 to 52.
50.
Page number 10, serial number 53 to 59.
Unwell ಅಂತ ಹಾಕೊಳ್ಳಿ. ರೇಣುಕಾ is unwell ಅಂತ ಹಾಕೊಂಡು. This matter on Monday. Yes.
Page number 11, number 60.
Correct. We are already into parted. This matter is parted. Senior counsel has already argued this matter. And whom do you appear for? You argue now. Let him address. Now it is already in a parted matter. Yes. Yes. Correct. But the thing was, the matter when it was listed for final hearing, there was no representation on behalf of the central government. None appeared, none appeared. So you should instruct the other councils, at least they would make a submission to the court that they have to file their objections.
Yes, yes, no, it's,
And-
it's getting for a long time. I was surprised that last several years we have not filed this. Now, I will personally drive it. I have told my PTC as well. I even to here, seek some accommodation I wanted from myself. I will drive it myself this course.
Since senior counsel has already addressed his arguments for the petitioner,
I mean, where is the challenge to the constitution? I think we should have filed these things. I think our team has taken it very rightly. I'm sorry about that. I will drive it myself.
PSG appears for the respondent. Sixth time to file statement of objections on behalf of respondent number one. The matter is in part heard. Petitioner counsel is being heard. And the counsel appearing for the respondent number two is heard in part. As the objections to the petition is necessary, since constitutional validity of provisions of ESI Act has been challenged. 2 weeks' time is finally granted. 3 weeks' time is finally granted to file their statement of objections. Yes. 24th for further hearing. Please inform, Madam, the senior counsel for the petitioner. Please inform. Otherly, court notice was ordered by this court. In fact, Rajendra is already appearing. Correct. This court on 22/8/2024 on the retirement memo filed by BM Siddhappa for respondent number 1 and 2. Court notice was issued to respondents 1 and 2, comma. It is brought to the notice of this court that S. Rajendra has already filed forward for respondent number 1 and 2 on 11th October 2022. In light of the filing of wakalat by S. Rajendra, issuance of court notice to respondents 1 and 2 would not arise. Hence, the portion of issuance of court notice to respondent number 1 and 2 on 22/8/2024 is recorded. Yes, this is the matter for the preliminary hearing B group. Hearing, idu. For final hearing, second appeal. Second. What is your name? So and so counsel submits that Shahbaz Hussain, learned counsel, has instructions to file power for respondents. Number 3. And what about others? KPTCL? Now, who is that? Who is the counsel appearing for the respondent number 1 and 2? The so and so counsel is directed to accept notice for respondent number 1 and 2. So 2, you take notice for 2 as well. 2 and 3, Shahbaz Hussain. 4, state SCGP to accept notice for respondent number 4. Petitioner counsel to serve the petition papers on the learned counsel. 3 weeks' time is granted to the respondents to file their statement of objections. This matter on 24. Yes. What is that? Similar.
So one day, for 25 connected matters, so prayers were different.
Yeah. So this matter is covered according to you. It is still pending. List this along with date February. 3 weeks time is granted to file a statement of objection. List this matter along with. Just give the numbers. Yes, madam. Entire amount, similar matter. Which is that writ petition number? Number, other name is. Subject to deposit of the entire amount, compensation amount within 4 weeks from today before the trial. Yes.
Number 6.
Yes. What is this Omkar Murthy? What is this matter about? Civil miscellaneous, huh? If the merchant notice to the respondent, there shall be a stay of the impugned order passed by the District Court in Civil Miscellaneous 174 of 2021 on the dated 1st March 2024, subject to the petitioner depositing the entire compensation amount as ordered by the District Court within 4 weeks from today before the trial court. Shubha, Shubha, yes. Just a moment. There's one serial number 6. Huh?
Yes.
Allah, Omkar Murthy. What happened to Omkar?
Same on the head.
Allah, 3 and 4 same. Oh? 5. Yes, 5 is ಇದರಲ್ಲಿ ಇದು ಈಗ ಮಾಡಿದ್ದು 6 ಅಲ್ಲಿ 5 ಕೊಡಿ KVO
Number 5.
ಬ್ಯಾರಿ ಕೊಟ್ಟಿದ್ದೀರಾ 22796 ಕೊಡಿ ಓಂಕಾರ ಮೂರ್ತಿ Omkar Murthy, no representation for the petition for this matter after 2 weeks.
Number 7.
Why is it in the preliminary hearing? There's already an interim order granted. So you file your objections. Representation. Really.
Subject matter is, ಸರ್ಕಾರಿ ಜಾಗದಲ್ಲಿ
Yes, yes. Yes.
From BJP officer to
Yes. Next, ye page number. Yes.
ಮಹಾನಗರ ಪಾಲಿಕೆ ವಾರ್ಡ್ ನಂಬರ್ 4 ವಸತಿ ವಾಣಿಜ್ಯ ಕಟ್ಟಡ ಕಟ್ಟುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಪಾಲಿಕೆ ಕಚೇರಿ ಸತ್ಯ ಕಟ್ಟಡಕ್ಕೆ ಮಂಜೂರಾದ ನಕ್ಷೆ ಪರವಾನಗಿ ನೀಡಿರುವ ದಾಖಲೆಗಳು ಕಂಡುಬರುವುದಿಲ್ಲ. ದಾಖಲೆಗಳಾದ ಖಾತಾ ಪ್ರಮಾಣ ಪ್ರಮಾಣ ಪತ್ರ, ಸ್ವಾಧೀನಾನುಭವ ಪ್ರಮಾಣ ಪತ್ರ ಮತ್ತು ಪಾಲಿಕೆಗೆ ಪ್ರತಿ ವರ್ಷ ಕಂದಾಯ ದಾಖಲೆಗಳು ಸಮಯದಲ್ಲಿ ಕಟ್ಟಡ ಮಂಜೂರಾದ This is not disconnection letter, my lord, by the Bescom authority against the not petitioner. Now, your lordship may kindly come to the annexure C. Running page number 17. This is the same thing, which I have purchased in my lord from Mr. Mohammad Sajjad Ali, from the my lord Mahesh K. That is on dated my lord 16/2021. Based on that, my lord, I have under the title, how able to get it my lord Tata, running page number 30, annexure D. This is A Tata, my lord. Very next to my lord 31. This is the QR code by Mr. Suraj A. Punjari, who has given my lord QR code. Here in this spot and given the A Tata. Very next is my lord property receipt. That is my lord annexure E, running page number 32. My lord, certificate, running page number 32. Construction fees, annexure G 36. Annexure H also may not same. That is may not 1,04,066 I have paid for the construction. Annexure H may not. Next is may not further document is also may not with respect to the payment to the DBMP. Then I think annexure A also may not. Then may not DBMP plan has been approved. Annexure A public license for the building that is house construction. House construction has been approved. Then building license annexure M. The lordship may kindly peruse my lord most crucial document. After these all documents when I placed it to the DBMP authority, DBMP authority has my lord themselves has given the building license permission. That is annexure M, my lord. Accordingly, my lord, I have started my construction. In the meantime, my lord, one third party has started to my lord give the trouble to me. He is a very influential person, my lord. His name is holding at the BJP only. He has started to disturb me. Then I approached the Honorable Civil Court. The Civil Court needs to grant a temporary injunction order. That is annexure M. Very page number 45. The trial court has not based a past detailed order with respect to the title and not by position.
The suit for declaration and injunction? So not title, only injunction. Injunction. Yes.
Then my lord, in the meantime, my lord, he is the influential person. Made a letter to the lord, to the press court. But no more in my that is annexure R. That is number 81. 81. This is the bottom level where they have disconnected. Then my lord, very next is my lord, temporary connection permission annexure S. Number 82. This is the my lord, temporary permission I have taken from the competent authority. They have given to me based on the my lord, my document. And my lord, now my lord, I am the strength of the my lord, honorable trial order as a respect to the title, physical position, and enjoying this institute property. Now, my lord, our influence is a first party without the reality. This one. And this one, based on that, madam has directed them to and
You continue that connection. Let's consider their objections. This is? So you consider, can they cannot disconnect the, so you're supporting the petitioner.
I'm only assisting.
Yes. Yes. So any illegality, anything that is for the BBMP to decide.
Yes.
They cannot disconnect the, they cannot disconnect the electricity connection on the pretext of there is a violation or any of the laws of the BBM.
Which direction might not that electricity can be restored. Now it's come to the.
It is for the BBMP authority to consider and pass upon. That you can give a application for permanent, to consider the permanent.
Sir, who is not a neighbor, third party who is somewhere may not, who is not decided left, right or center of the house. He is totally away from the residential area. Who has not the complaint, according to both the respondent authorities are acting illegal act. It's not essential service, you will always want to disturb. Based on document, learned trial court has considered after detailed argument and there are observed a detailed.
Yes, yes.
Favorable order would never only expect to say, then never learned single judge of the sort of the court, or parallel court, as confirmed the order.
Parallel ಅಂದ್ರೆ ಏನ್ ಹಿಂಗೇನಾ?
Coordinate. It's coordinate which lordship has considered.
Yes.
But serious what my government says that all authorities and all properties is in this situation. Maybe this is the connection. But analyzing everything, has been already observed by
Yes. Bani.
so the liberty may be considered to be
Yes.
permanent.
So if it is permitted in accordance with law, consider their application. And that is how the law is.
They are taking the permanent connection in the.
You can always say you complete the construction. The action on part of the respondent number 2. Respondent number 2 and respondent number. Ashta respondent number 2 alva. The action on part of the respondent number 2 has made the petitioner approach this court in this writ petition. The petitioner has purchased the petition property white register sale deed dated 17/8/2021. Pursuant to the sale deed executed in his favor, he has effected change in Khata and Revenue Department. The petitioner, after obtaining the sanction and building license, started putting up construction in the petition property. The one BJP Murli, when interfered with the possession of the petitioner, the petitioner approached the civil court in OS number 799 of 2024 for permanent injunction and for consequential relief against the said person. The trial court granted temporary injunction in favor of the petitioner, restraining said BJP Murli from interfering with the peaceful possession and enjoyment of the suit property. Aggrieved by the order of the trial court granting temporary injunction, the BJP Murli had approached this court in MFA 4926 of 2024. And it is brought to the notice of this court that MFA preferred by the BJP Murli has been dismissed. It is the case of the petitioner that the petitioner, being the absolute owner of the suit property and having obtained the building license, was putting up construction. The fourth respondent has issued a letter to the second respondent to disconnect the temporary electricity connection. It is the case of the petitioner that the petitioner has placed all the documents of his title in terms of the notice issued to him on 29/6/2024. The respondent number 4 authority has illegally sent a letter to the second respondent for non-providing the documents and ordered for disconnection of temporary electricity power supply. The perusal of annexure, which is that annexure A, and which is at Q, annexure Q, A, B and Q. A and Q is the letter issued by the BBMP. A and B. The perusal of annexures B and Q indicates that BBMP had addressed a letter to the BESCOM stating that the construction put up by the petitioner is illegal, as he has put it on the government land. And on the basis of the letter issued by the BBMP, the BESCOM has proceeded to issue notice at annexure A 11/7/2024, and it is stated by the petitioner counsel that the BESCOM has disconnected the electricity connection to the petitioner's installation in the month of June 2024 and July 2024, and pursuant to the interim order granted by this court, the BESCOM has restored the electricity connection. If the contention of the BBMP is that the petitioner has put up any illegal construction, the course available to the BBMP is to take appropriate action in accordance with it. But on the behest of BBMP, the respondent number 4, BESCOM, cannot disconnect the electricity connection. No, but even whatever it is, let him take his course. That is not available for the BBMP. Illegal connection. That is the action on the part of the BESCOM in depriving the electricity connection is violation of Article 14 of the Constitution of India. The electricity being an inherent right of the petitioner cannot be deprived, of a citizen cannot be deprived, and necessary direction is issued to the respondent number 4 not to disconnect the electricity connection of power supply, not to disconnect the power supply to the petitioner's residential site, petition site, and the petitioner to continue to pay the charges, consumption charges. Consumption charges. In light of the petitioner having made out a case, this court passed the following order. The petition is allowed. The impugned orders at annexure A is quashed. The petitioner to file objections to annexure B, dated 29/6/2024, and the respondent authority number 4 to consider the same in accordance with law. Till then, the power supply to the petition property not to be disconnected and the consumption charges to be paid. Yes. Then, in an event, the petitioner files an application for permanent supply, the respondent authorities to consider the same in accordance with the said observation that petition stands disposed. BBMP, it is for them to accordance with law ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, you can produce all the documents. Yes, learned counsel for the learned counsel L. Shekhar submits that the records are with the state and the state would be directed to get the records. In light of the submission, calling for TCR would not arise. The SCGP to secure the records on the next date of hearing. List this matter on list ಅವ್ರಿಲ್ ತರ್ಬೇಕಲ್ವಾ. List this matter on Monday. B group, in B group. In preliminary hearing, B group. Who is respondent number 2? You take notice for respondent number 2. He is an administrator. No, respondent. You have, yes, you already, what is there to seek instruction when you already appear for one administrator, then the representative of the other office has to be represented by you. We will say you take notice. Respondent number 1 has filed wakalat for the Matha. The respondent number 2 is the representative of Sringeri Sri Shankar Matha branch office. Respondent number, in light of the same, respondent number 2 is directed to accept notice. So learned counsel K.R. Krishnamurthy is directed to accept notice for respondent number 2 to file wakalat by a week. Yes.
Number 10, Mohammed Hussain Sharif.
Yes, who is respondent number 3 to 5? Where is the petitioner counsel? What is that? Petitioner counsel submits that needful has been done. Office to verify and proceed. Yes. At request of the petitioner counsel, a week's time is granted to do the needful. Yes.
Number 12,
Yes, Mr. Madhukar Deshpande. Await service of notice in respect of respondent number 3. Yes, next.
9,
What is the direction?
For 5 days. And that day I personally appeared before your office. And I stated that they are not coming for the job, in spite of order, the increase order passed by this honorable. Because they are appeared to KBS. And in front of them only this order was passed. So on that day, lordship was authorized, this is not enough to lordship. So it will be the next day, then morning they appear, the second of they did not appear. At that time, your lordship suggested that they are going to not this is not in the because one I think of electric computer, not in another. I was she stated that now our ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಆಮೇಲೆ ಪಾಸ್ ಹೋಗ್ಬೇಕಿದೆ ಅದಕ್ಕೆ ಈ ತರ ಅದಕ್ಕೆ ನಾನು ಔಟ್ ಕರ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ.
See, there's an order passed by this court that the petitioner seeks time to produce the materials, documents to indicate that they had directed the respondent to join the services. Then, Allah, you said that despite the notice issued by you to calling upon the respondent, directing them to join the service, they have not joined, and was your contention.
We can take that with this one now. But here, see, don't they appear on that?
Last time,
Now, let me put in detail. Our building are there, then I will get the end of the year,
See, there is an order passed by this court that is staying the impugned order subject to reinstatement. When there is reinstatement order, you have to issue notice to the respondent. Mr. Consul, you have to issue notice to the respondent calling upon them to join the services. When is it not? Then a submission was made by the petitioner counsel that the notice was issued to the respondent despite that they have not joined the services. So you said that you will produce the document. That is the order.
My earlier, previous day, with 5D, I submitted to this. They did not come. And my even submission to your worship is, we have not issued any notice to them.
Allah, there is no order.
Our senior counsel did that. Again, order
First time it is
senior counsel. All you did find out things that ವಾಪಸ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ ಇವರಿಲ್ಲ ವಾಪಸ್ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ ರಿಜಿಸ್ಟರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ ಅಂತ ಹೇಳಿ ಸೀನಿಯರ್ ಮುಂದೆ ಸೀನಿಯರ್ ಅಂತ ಸರ್ ಇಬ್ಬರು ಇದ್ದಾಗೆ
6 ವರ್ಷ ನಾನು ಮನೆಯಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದೀನಿ. ಆಗಲೇ ನಾನು ಇರಲಿಲ್ಲ.
ನಾನು ಬೆಳಗ್ಗೆ ಮಧ್ಯಾಹ್ನ ಬಂದಿದ್ದೀನಿ.
5
ಏನು
So you are not issued notice. So now how do you say that they have refused to join your service?
First they have filed what industry inspect. In that also we have clarified. Pending the request also to pay the party. In that also we have specifically stated. We have specifically stated that if a petitioner is willing to join the employment of the earlier, and he has welcome to the work.
This is, Allah, it was produced before the labor court. Labor court has considered this and said that you have not made any efforts to reinstate them. Yes.
It is respectfully submitted that the second party at no point of time refused employment to the first party. Now may request your lordship to last page. The page number 73. Every way, from the day one, I have not refused, that's what my submission is. From day one, I have not refused employment to be. Before the honorable court, when I posted, we have a order. Then also, it was in front of their protocol, they came to Deviata. They stated that, nowhere we have denied their employment, but only we are challenging the our 3 lakhs that will pass. We are challenging that one, that's what we have stated. So after that, they want to.
If you are not, if you are ready, see, this is on.
No days they have whispered that I have denied that they are not allowing them to get that. They want, we are saying you are welcome to the job.
You reinstate them today itself. You go and join. You go and join now. See, not joining the employment. Are you ready to join now? Join ಮಾಡಿ ಆಮೇಲೆ. Let us see. You go and reinstate. You go and join the services. ಮತ್ತೆ?
ಅವಾಗ ನಾವು ಬಂದು ನೀವು ಕೇಳಿದ್ಕೆ ಹೇಳ್ತಿದ್ದಾರೆ
ಅಲ್ಲ ನೀವು ಜಾಯಿನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಹೇಳ್ತೀರಾ, ಯು ವಾಂಟ್ ಟು ಜಾಯಿನ್ ಅಂತ ಹೇಳ್ತೀರಾ, ಅವರು ತಗೋತೀನಿ ಅಂತೀರಾ. ಲೆಟ್ ಅಸ್ ಸಿ, ಯು ಗೋ ಅಂಡ್ ಜಾಯಿನ್, ಲೆಟ್ ದೆಮ್ ಟೇಕ್ ಯು ಇಂಟು.
ಬಂದು ಕೇಳಿದಾಗ ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಲ್ಲ ನಾವು ಬರ್ಸ್ ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಲಾಸ್ಟ್ ಇಯರ್ ನಮ್ಗೆ ನಾವು ರೀಸ್ಟೇಟ್ಮೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತೀವಿ.
ಆಯ್ತು, ಈಗ ಹೋಗಿ ಜಾಯಿನ್ ಮಾಡಿ. ಲೆಟ್ ಅಸ್ ಸಿ, ಗೋ ಅಂಡ್ ಜಾಯಿನ್ ಆನ್. Then comes the question of 17B wages. But ಇಷ್ಟೆಲ್ಲ ಯಾಕೆ argument? Why did you argue the matter? Decision ತಗೊಳ್ಳಿಕ್ಕೆ senior counsel ಬರ್ಬೇಕು. ನೀವು ಸುಮ್ನೆ argument ಮಾಡಿ ಹೋಗ್ಬೇಕಾ? What is that to clarify? Then why did you argue? Why did you argue? This makes the court to pass wrong orders. Yes. You knew what is the submission. You knew what is the submission. You wanted to take a chance. Is it not? Chance togobedi. Don't take a chance before the court. Don't take chance. Don't take chance. You come Mr. Senior Counsel. 2:30. Now we are not sitting in a review of this. We are not sitting in a review of the order passed by this court. You can also challenge this in the writ appeal.
Because it will lead to multiplicity of proceedings again. That is the reason why I am
Yes, what is?
The judgment of the judicial law will today not be accepted. Judgment not of rights. Now, not here unnecessarily not taking it there. The ground is not the raised ground objection. Only they cite a Bombay High Court, to cite it before the song. But refer to that. But has no bearing at all. Because what happened that case when you
the court is in the judgment of the Bombay. That also
But when we go back to the judgments, page 55. Here they have produced the judgment. Interim page 51, serial page 55 is IA. Serial number 34, first judgment. Then your lordships have listed all the judgments cited. That serial 34, this Sachin Vijay Desai versus Union of India. This judgment not they rely upon. To say that the Bombay High Court has taken a different view. Actually, Bombay High Court did not consider this aspect at all. Now, case how was their law. An Indian worker said, international worker can contribute any amount without apology. I am not given that. Therefore, not he said, I am not be given the same benefit.
I think that judgment was referred to by this court and then distinguished.
And I made sure he said, Determine page 72, paragraph 28. Non-citizen employee.
Yes.
Working in India, employees who are citizens of India are different classes for some reason. When working in India are equal, equals are treated differently. Hence violates Article 14. The Bombay High Court law doesn't consider this argument the object of this classification. It proceeds on the basis that it is admitted that they are equal.
I think this court has distinguished that aspect. Is it not?
It is not, this is a reference to that aspect.
No, remember.
Space and judgment, you consider the conclusion is not that there is no basis. So also one more aspect the same objection is SSA agreement community non-agreement. That also been dealt with by this court. Now, when you check the notice law, there is only 20 countries, India government has an agreement. Other countries, protection not available. In fact, your worship could not have dealt with this. Page number 71. This argument is now saying objection is also considered. There on page 71. Para Roman number 2, the first paragraph. The claim of reciprocity involves land has no legs to stand in respect of independent purpose from non-SSA countries. It is also brought to the notice before. As of now, only 20 countries have entered into SSA. Though para 83 was introduced long back in the year 2008, 16 years ago. To be concerned, these petitioners are international workers whose country of origin has not entered into a bilateral treaty with the Union of India with regard to the social security scheme. There is no material to show what is social security scheme available for such international workers. Country of origin has not entered into bilateral agreement. Conclusion that there is a discrimination. For both these arguments which they are now raising, maybe of objections, consider their
Is there any, is there any interim order?
No, that is why it's
Madam, only when there is an interim order, we can stay the proceedings or keep this matter in abeyance. If there is no stay, can you pursue, madam, madam, can you persuade this court in the pretext of filing a writ appeal, the matter has to be kept in abeyance? Is it permissible? What stands the field now as on today? What stands the field? No, we can understand your writ appeal is pending. Is there any stay granted? If there is a stay granted, we will. Then this order was passed in the month of March or April.
Divided in June with delay.
Delay.
It is not delayed.
Whatever. Now that, how can you say that this writ petition has to be stalled on the pretext that a writ appeal has been filed by you?
So I am requesting this court to keep it pending for 2 weeks.
For what reason? For what reason?
Like, we get a stay, then again I have to challenge this order, it leads to multiple.
No,
This
then
is the reason why I am.
if at all there is a stay, then we can stall it, but not if there is no stay by this court.
This is the mandate situation because only when we it is the all the so one case comes up
As a last chance, we'll give it on senior counsel.
The dispute here relates only to damages. So any other
Damage.
case coming will not have parallel to this. Now, they are all related to cases where they say we are not liable to.
Not liable.
Yeah, but this case should stand on its own. I don't see what purpose.
You paid the amount earlier, and what was the reason? What was the reason for claiming damages?
It was a delay for what that was. The time it is. Our internal education process not there is no. Before any demand, now they say, don't come and pay 400 crores, 100 crores. Now they say, 100 crores penalty is being imposed on the damages and the court. So this case is very unique to no other case is important. It will talk about. Ultimately, no, it remains subject to result of that appeal also. I have no problem.
The demand made is from the month of April 2021.
It is not that important. There are 3 petitions to law. And you will also
Yes.
The first step is for related breaches. The between 1/4/17 to 30/3/18.
Yes.
Amount paid, principal amount, damages only this. Contribution is already paid, 82 crores, plus interest 49 crores. Second repetition amount is 1/4/18 to 31/3/19.
So this is the amount they had claimed as damages against. On damages, there's an interest charged by.
No.
No.
This is not a contribution.
Contribution.
We have paid the.
But then after they pay the contribution, you charge interest again on.
For the delay.
For the
We paid
delay.
the cost. Interest is also paid. Only dispute now is not damages. Tribunal there. You're also
CGIP is not working, right? It's not working.
There is a stay of his order.
Correct.
That may be continued and academic teacher.
There's no other parallel case to this. If they succeed in that agreement.
Correct. In the event you succeed in the appeal, you can seek for revival of this order.
Next time may be granted because the appeal will come now. So thereafter then the case can be.
But 3 times it has been gone. See, not any
So with
justification. Not if government has to file one more appeal, you know, they are not some indigent, poor farmer who have no value to pay.
We will list it on Tuesday, Wednesday. With not further than that. With the nice, we will say what is the contention of senior counsel. We will take that on record and we will say that you would say that writ appeal is preferred and the matter is pending consideration, but there is no stay granted, but they are pressing for the interim order. Let us see what will happen. Learned senior counsel appearing for the petitioner SS Nagaland submits that the present writ petition.
Government has not filed an appeal also.
They have not filed. The main aggrieved person is not at all. Central government is not prepared. Please learn senior counsel so and so for the SS Nagaland for the petitioner submits that the present writ petitions are squarely covered by the decision of this court in WP 18486 of 2012 and connected writ petition, which was disposed of on 25th April 2024. Learned counsel appearing for the Regional Provident Fund Commissioner submits that the respondent have preferred writ appeal against the impugned or against the order dated 25th April 2024. In writ petition 18486 of 2012, in writ appeal number covered, and the same is pending consideration, and the respondent is pressing for an interim order. The fact remains that the writ appeal has been preferred in the month of June 2024, and there is no interim order operating in favor of the respondents. As a last chance, is this matter on Wednesday? No, Wednesday. 13th. 13th of October. What? Wednesday. Because we don't take writ petitions on Thursdays and Fridays. On Wednesday. 11th as a last chance. When do you want? 30? 12. 12.
Let's,
I appear for the respondent.
for the,
Yes, senior
for
counsel.
the petitioner, my lords.
Yes. Yes, senior counsel.
My lord, so far as I am concerned, my lord, there is an interim order which has stayed the order passed by the Labour Court
Ah.
granting interim relief.
Yes,
Now, there is no application filed by the respondent or
The matter came up last week. My
This
learned
matter
friend said that the matter
understand-
itself can be considered since it is against an interim order passed with the Labour Court.
the matter is to be considered on merits now. That
Yes.
was the understanding with
Yes.
the matter is listed today. Yes, Murthy, sir,
yes, my lord.
the matter has to be heard on merits. That was
Yes,
the.
my lord. Yes, my lord. My submission is this, my lord. The interim order has been granted.
Ah,
Now, my lord, my submission is this. If your lordship sees section 17, 17B, kindly see the provision.
yes,
Payment of full wages to workmen pending proceedings.
yes,
Miller's payment of full wages to workmen pending proceedings in higher courts, where in any case Labour Court Tribunal, National Tribunal by its award directs reinstatement of any workman and the employer prefers any proceeding against such award in a high court or the Supreme Court, the employer shall be liable to pay such workmen during the period of pendency of such proceedings in the High Court or the Supreme Court, full wages lost drawn by him inclusive of any maintenance allowance admissible to him under any rule if the workman had not been employed in any establishment during such period and an affidavit by such workman had been filed to that effect in such court. Now, my lord, I may pause here for a moment. Your lordship sees 17B will come only when an award is passed directing reinstatement. In the present case, the matter is still pending. The 17B cannot come into picture because only when by award direct reinstatement and the employer prefers proceedings against such award.
yes,
No award is passed.
yes,
So 17B question doesn't arise at all. It cannot come. It is only an interim order made
yes,
without going into the merits and without any award being passed. So
yes,
17B will come into picture or may help my learned friend on the other side only when a tribunal is passed by the court directing reinstatement. Now, there
Yes.
is no order of reinstatement in this case so far.
yes,
So, the question of trying to seek a sort of to contend that the relief given to the company, to the petitioner, should be deliberately dismissed. The relief given will not arise.
yes,
Because as I submitted once again, that only when there is an award directing reinstatement 17B comes.
yes,
In absence of award, 17B cannot be gone into.
yes,
Now the only question is whether whether I make an application seeking interim order passed by the Labour Court, whether the order passed is justified.
yes,
Two things. Firstly, the 17B order award of reinstatement has not arisen as such. To say that you should not get or the court should not grant will not arise. Now, second point. Let us see what and how the order is. The other side wants to claim that the order should be deleted or otherwise. Now, first and foremost, there is no objection filed so far as my application is concerned. I have made an application and this court has passed an interim order and no objection is filed by the respondent.
Yes.
Then kindly see, mirrors. Kindly see, I have produced the Supreme Court judgment along with in para 14 and para I have filed on 29/2021.
Yes.
Kindly see para 14, mirrors. Page 4, that is
Yes.
para 14. It was sought to be urged that after coming to a finding on the basis of the evidence of the respondent himself, that during the period of termination of his services, he was engaged in agriculture and that he was receiving certain amount therein, it was not open to the labor code to observe that gainful employment would not include such income from agriculture. It was urged that income from any source, whether from employment in an establishment or from self-employment, would have to be treated as income for the purposes of deciding whether the respondent would be entitled to receive full back wages. It was urged that both the tribunal and the High Court erred in taking a view to the contrary, and the order passed on the basis thereof were liable to be set aside. Then para 17. On the said question, we are unable to accept the reasoning of the labor court that the income received by the respondent from agricultural pursuits could not be equated with income from gainful employment in any establishment. In our view, gainful employment would also include self-employment, wherein income is generated. Income either from employment in an establishment or from self-employment merely differentiates the source from which income is generated, the end use being the same. Since the respondent was earning some amount from his agricultural pursuits to maintain himself, labor court was not justified in holding that merely because the respondent was receiving agricultural income, he could not be treated to be engaged in gainful employment. 18, paragraph. The single judge of the High Court, without looking into this aspect of the matter, merely observed that the management had not established that the workman was engaged in any gainful employment during the period of dismissal, and on such finding, the learned single judge chose not to interfere with the award as by the tribunal after remand. The division bench which heard the writ appeal did not also consider the aforesaid aspect of the matter and mechanically disposed of the appeal with the observation that after going through the order of the learned single judge and the award tribunal, it found no ground to interfere with the findings recorded therein. In view of what we have stated here and above, regarding the income received by the respondent for the period of his dismissal from service till the date of the award, we are of the view that the award passed by the tribunal after remand and affirmed by the High Court, both by the learned single judge and the division bench, is liable to be modified, and the earlier award of the labor court dated so and so is liable to be restored. What the sum and substance of this judgment is? It is not necessary. Any income that is received even from agricultural property or agricultural income is sufficiently good enough.
Yes.
Only when 17B comes into picture, when your lordship may see 17B and the proviso there, your lordship will get the correct position. In 17B, provided, lordship may see 17B, it says, provided that, lordship gets not 17B.
Yes.
Provided, that is, I'm reading 17B.
Yes, yes.
Provided that where it is proved to the satisfaction of the High Court or the Supreme Court that such workmen had been employed and had been receiving adequate remuneration during any such period or part thereof, the court shall order no wages shall be payable under the section for such period or part as the case may be. Now, therefore, my submission is that ultimately, if in any establishment the workman is working, only then it can be taken as employment by the employee.
Yes.
That is how in 17B, first part itself, the court says in the last 3 lines, Supreme Court, full wages lost on by him, inclusive of any maintenance allowance admissible to him under any rule, if the workman had not been employed in any establishment.
Yes.
This is correct. This is for 17B. Now we are not dealing with the case of payment of last drawn wages under 17B because it is not an award. Therefore, in such a case, the question was whether gainful employment could be said to be existence if a workman gains or earns agricultural income. Now, in my case, there is a evidence given by the workman himself that he had, I have produced also that he has 2 acres of land. Kindly see, my lords, I page at 72 in my paper book.
Yes.
Kindly see 72, my lord, last 2 paragraphs. Presently, the last at page 72.
Yes.
Presently, I am residing at my native place of Haveri. It is true that to suggest that we are residing in our own house in my native place and my wife is working as a nurse. I have got 2 children and my mother. Then he says very clearly in next sentence, last line, I own 2 acres of the land which is cultivable by me. So he says he has got 2 acres of land, he cultivates. His wife also is employed.
Yes.
Now, Supreme Court says, yes, if he's able to show that, if you are able to show that he's employed, earns through agricultural land, that is sufficient. And therefore, grant of wages for the period does not arise.
In this case, domestic inquiry was held to be fair and proper.
Domestic inquiry was set aside. Now, when
So what means for fresh evidence,
now I have to lead evidence on merits.
merits?
Now, in the meantime, on an application filed by the respondent, this Honorable, the Labour Court, granted an interim leave.
Yes.
Now, therefore, the question is, the court below, while granting, your Lordship may see, in the order passed by the court, it
Yes.
says, at page 70, paragraph 13. On going through the observation of our Honorable High Court of Karnataka, both the decisions that the tribunal has conferred the right to consider the interim relief even before giving the findings of validity of the domestic inquiry. Whenever the employee had nothing to maintain himself, there is no dispute of relationship of the employee with the employer, and even the gainful employment is also not proved at this stage, and domestic inquiry held as not fair and proper. Such is the case. It is the burden lies on the management to justify the order of dismissal passed against the opposite party. When such is the case, there is a power conferred under Section 10(4) of the ID Act to grant the interim relief. So the tribunal needs to exercise the power conferred under law to provide at least minimum 50% of the last paid salary drawn as an interim relief to bear minimum expenses of the opposite party. With this observation, the tribunal has arrived at the conclusion that in this case there are prima facie ground made out to consider the interim leave application to receive the interim relief from the date of dismissal till the date of disposal of the present case.
Yes.
Now, this is wrong. Evidence was there that he was gainfully employed because of his agricultural income. He had 2 acres of land. It is his own house is there. He has been
Yes.
working there, and his wife is employed as a nurse. All those things, nothing is discussed. Simply it says 50% I should be given. At least the court should say it will not accept my submissions that he has 2 acres of land, that he's got one house, that his wife is also employed. She's a nurse. Therefore, my submission is, my lords, to say that the employee should have been given interim relief, because without going to the question whether he is gainfully employed or not, in spite of my producing evidence, in spite of the workman himself accepting, the order, impute order, is liable to be quashed, my lords.
Yes.
Much obliged.
Yes. Yes,
Lord,
senior.
I appear for the respondent.
Ah.
Lord, the order by which the domestic inquiry is held to be not fair and proper is found at page 50, which is not under question here. At page
Yes.
50.
Ah.
So once the domestic inquiry is held to be not fair and proper, then, my lord, until the tribunal, the labor court decides the matter, the relationship of employer and employee continues. Even in a case of a suspension, the subsistence allowance is granted. That is the rule. Now, in the present case, once it is held that the domestic inquiry is not fair and proper, the labor court is entitled to pass an interim order. Now, my
Yes.
learned friend is not right in saying that the question of granting an interim order does not arise at all, because that issue stands covered by several judgments of this court as well as by the Supreme Court. Now, kindly see page 67 of the writ petition, where these 2 acres of land is referred to.
Yes.
Page 67,
Hmm.
about 8
There is
lines from the top.
There is nothing elicited during the cross-examination.
Yeah, mere there is an admission of owning 2 acres of land is not sufficient unless it is explained the nature of the crop grown and availability of water facility to grow the crop, etc. Now, in the present case, Lord, my learned friend contention is my wife is working as a nurse, so therefore I am not entitled for this 50% back wages. Now, kindly look at the order, Lord, the Supreme Court judgment which my learned friend relies upon. Even in a case where there is proof of getting income from agriculture, which is not here in the present case. Kindly see that Supreme Court judgment in Northeast Karnataka Road Transport Corporation, para 8. Para 7. On 20-10-94, the Labour Court heard the issue as a preliminary issue, held that the domestic inquiry was not fair and proper. On 3-1-95, while the proceedings were pending before Labour Court, the respondent filed an interim application which was allowed by the Labour Court, and the appellant corporation was directed to pay 50% of the salary loss drawn by the respondent. In the aforesaid order, appellant was permitted to obtain work from the respondent on the strength of a joint memorandum filed by the party. Subsequently, on 23-98, the Labour Court allowed the respondent's claim petition by ordering a reinstatement into service and also holding that he was entitled to receive 50% of the back wages. Agreed by the aforesaid order, the respondent filed writ petition number so-and-so before the High Court of Karnataka, which remitted the matter back to the Labour Court with a direction to pass appropriate orders with regard to back wages, continuity of service, and other consequential benefits, after affording an opportunity to both the parties. After remand, the tribunal, by its order dated 10/8/2001, allowed the reference held that the respondent was entitled to receive full back wages from the date of the order of dismissal till the date of the award with continuity of service and all consequential benefits.
Yes.
Now, kindly go to para 13.
Yes.
At the very outset, it was submitted on behalf of the appellant that the corporation had no grievance against the award as was made by the Labour Court on 23-98, that the corporation was ready and willing to reinstate the respondent, pay 50% of the salary loss drawn by him. The corporation has, however, agreed with the subsequent award passed by the Labour Court after remand, whereby the Labour Court altered its earlier direction after coming to a finding that respondent was entitled to full back wages, not 50% as had been directed earlier. In this case, there was proof of getting income from the agricultural property. Here it is not there. There is not even a suggestion that I was getting some income from the agricultural property. In this case, my lord, also an interim order was passed by the Labour Court when the matter was pending, directing them to pay 50% back wages. In the present case also, what is paid is only 50% of the back wages, not 100%. If that is a matter, my lord, which they will have to consider at a later stage. Now, kindly see, my lord, the compilation which I have given, this issue has come up on several occasions. Kindly see the list of citation which I have filed on 29 September 2021.
Yes. Yes.
There, my lord, at ink page 3, paragraph 5. Subsection 3 of section 33.
Which judgment you are referring to? Standard
That is, my
Chartered.
lord, that is Fakir Bhai, Pula Bhai, that is AR 86 Supreme Court 1168. There are two compilations. One is the list of authorities, another is additional list.
Yes.
There, my lord, para 5. Subsection 3 of section 33. Lord, you got it?
Yes, yes.
Of the Act provides that notwithstanding anything contained in subsection 2 thereof, no employer shall during the pendency of any such proceeding, in respect of an industrial dispute, take any action against any protected workman concerned in such dispute, A, by altering to the prejudice of such workman the conditions of service applicable to him immediately before the commencement of such proceeding, or B, by discharging or punishing, whether by dismissal or otherwise, such protected workmen, save with the express permission in writing of the authority before which proceeding is pending. It follows from the provisions of subsection 3 of section 33 of the Act that workman does not cease to be a workman until the tribunal grants permission to dismiss the workman and the management dismisses the workman pursuant to such permission. An order of suspension by itself does not put an end to the employment. The workman continues to be an employee during the period of suspension, and it is for this reason ordinarily the various standing orders in force in several factories and industrial establishments provide for payment of subsistence allowance, which is normally less than the usual salary, and allowance are paid to the workman concerned. An order of suspension no doubt prevents the employee from rendering his service. It does not put an end to the relationship of master and servant between management and the workman. When an application is made under 33(3) of the Act, workman is entitled to defend himself before the tribunal. In those proceedings, it is open to him to show that domestic inquiry held against him was not in accordance with law and principles of natural justice, and action proposed to be taken against him by management is unjust, should not be permitted. Sometimes it may be necessary to either of the parties to lead evidence even before the tribunal. The proceedings before the tribunal very often take a long time to come to an end. In this very case, the proceedings were pending before the tribunal for nearly 6 years. Most of the workmen are not in a position to maintain themselves and the members of their families during the pendency of such proceeding. In addition to the cost of maintenance of his family, workman has to find money to meet the expenses that he has to incur in connection with the proceedings pending before the tribunal. In this case, the appellant was in receipt of salary and allowance till the end of disciplinary inquiry. But from 13/8/79, he was not paid even the barest subsistence allowance till August 5, 1985, when the tribunal passed its order award on application of the management and the complaint of the appellant. It is true that in the instant case, tribunal granted the application of the management, rejected the complaint of the appellant. It was also quite possible that the tribunal could have rejected the application of the management, upheld the complaint of the appellant, in which case the appellant would have been entitled to continue to be an employee under the management of the factory, and the disciplinary inquiry held against him would have no effect at all. Because it is difficult to anticipate the result of an application made before the tribunal, it is reasonable to hold that the workmen against whom application is made should be paid some amount by way of subsistence allowance to enable him to maintain himself and members of his family, and also to meet expense of the litigation before the tribunal. And if no amount is paid during pendency of such an application, it has to be held that workman concerned has been denied reasonable opportunity to defend himself in the proceeding before tribunal. Such denial leads to violation of principles of natural justice and consequently vitiates the proceedings before the tribunal under subsection 3 of section 33 of the Act. Any decision given in those proceedings against the workman concerned, no material has been placed before us in this case to show that the appellant had sufficient means to defend himself before the tribunal. Now, my lord, kindly see there are several judgments, but I will only refer to one or two judgments. Page 39 is the division bench judgment of this honorable court. ILR 2001 Karnataka 890 at page 39. At page 40, the first line. The short question that arises for consideration is at what stage interim relief can be awarded to a dismissed employee while a labor dispute is pending adjudication before the labor court, industrial tribunal, as the case may be. The following observation made by this court in TT Limited versus R. Subramaniam and another is the foundation for the said contention. The management contended before tribunal that the ratio of the decision in Mysore Cement's case was that the labor court had jurisdiction to grant interim relief only from or after the date on which domestic inquiry was held to be invalid. The learned judge rejected the contention, holding that that was not the ratio in Mysore Cement's case. We are in respectful agreement with the view taken by the learned judge. In the Mysore Cement's case, this court held that when an application for interim relief is made by a workman during pendency of an industrial dispute, labor court in the first instance should consider as to whether domestic inquiry was valid or invalid. Thereafter, proceed to grant the relief. If the domestic inquiry is invalid according to the said decision, interim relief should be granted after recording a finding that domestic inquiry was invalid. That same issue, my lord, has been elaborated in that judgment. In para 5 also, my lord, they reiterate the same position that once domestic inquiry is held to be invalid, the court, labor court, has the power to, the conclusion part of it I will read, my lord. Para 8.
Yes.
Hence, if the tribunal or the labor court is yet to pronounce on the propriety of the punishment imposed on the worker is equated to the status of employee suspended pending inquiry. If so, any payment in the form of an interim relief is nothing but subsistence allowance contemplated under service jurisprudence. In such a situation, to contend that the finding on the domestic inquiry by the tribunal labor court is sine qua non for considering as to whether interim relief has to be granted or not is not a correct position of law. But in this case, that also issue does not arise because now the finding is there that the domestic inquiry is not fair and proper. And though the 17B, straight away the principle, the object behind 17B would apply because 17B would be a case where the reinstatement is ordered. Here is a case where the labor court is yet to decide on the correctness of my dismissal. So I continue to be an employee. So therefore, that principle which is there in 17B would necessarily apply where there is no dismissal at all. But in this regard, whether the self-employment or not, there is an additional list of authorities, only 1 or 2 judgments I will point out. In the additional list of authorities filed on 3/11/2022, though this was in the context of 17B, this would apply to our case also, Lord. Additional list of authorities.
Yes.
The first judgment of Justice Devdas
Yes.
at paragraph 8. In fact, at page 9, para 8. In fact, in the matter of Bhanulal Kimjibai Solanki, a contrary view taken by the learned single judge was considered wherein the dismissed workman was self-employed by plying an auto rickshaw or rickshaw or was doing hawking, and therefore the learned single judge was of the opinion that such self-employment would also render the dismissed workman disentitled for seeking wages under section 17B of the Act. This opinion of the learned single judge was not accepted by the division bench. This court is in respectful agreement with the decision of the division benches of the High Court of Gujarat as referred to by the learned counsel was the respondent workman. A plain reading of provisions makes it clear. Workman is entitled for receiving payment of full wages during the proceeding initiated at the hands of the employer before the High Court or Supreme Court if the workman had not been employed in any establishment, and an affidavit in that regard is filed by the workman. The court need not go any further into the proviso of 17B, since admittedly it is the contention of the petitioner that respondent workman was gainfully employed on self-employment by owning, driving an auto rickshaw. He was deriving adequate remuneration during the period. In view of the above, court is satisfied that the respondent workman is entitled for payment of full wages last drawn by him, including of any maintenance allowance admissible to him under any rule. So this word was confirmed by the division bench at page 14, this judgment. This is a case, Lord, where full wages are to be given. But in my case, what is given is only 50% of the back wages. Even if we take the Supreme Court judgment, which my learned friend relied upon, There also an interim order was granted only for 50% back wages. Ultimately, 50% only it has been upheld. Now, here is not a case where I am claiming for 100% back wages. That being so, beloved, this is a discretionary order. And that is not a case, an establishment, big establishment like Toyota, I am dismissed only on the ground of allegation of go slow tactics. That is the only ground. So, an establishment like the petitioner establishment, that is not justified on denying even on the subsistence allowance. And to advance an argument that I should, even my wife should not work, Lord, is an extreme proposition. That being so, Lord, this is a discretionary order which does not call for interference in my submission.
Yes. But senior counsel, it's a notice for the petitioner.
My lord, may I make one submission, my lord? My
Yes,
learned friends, reference to the various judgments is not a correct position. But what we are submitting is that if the management is able to show that the workman is gainfully employed, he will not be entitled to any interim relief. Therefore, the contention is everything of what my learned friend is right, except stating that the court will have to simply give because the inquiry is set aside. Not necessary. Inquiry may be set aside. Assuming a workman is gainfully employed, even if the inquiry is set aside, it does not mean that the workman should be given an interim relief. My submission is the court granted 50% without considering the submission that the workman had 2 acres of land, he was working in that, he has a own house, he has a wife working in. These factors will have to be determined, forgetting whether inquiry is fair or proper or not. Assuming there is an inquiry is fair and proper in a case, if the management is able to show that he is well employed, the court cannot grant merely because the inquiry is set aside. Therefore, my submission is where the labor court has erred is in not considering my submission with regard to the occupation that the workman has, the land that he has got, the land that he is working on, and the wife working. Therefore, in the light of absence of this observation or reference, the impugned order is liable to be set aside. My submission. In fact, your lordship may kindly see at para 17 at page 10.
of the trial of the labor court order.
No, my lord, see, it is a part of the writ petition at paragraph 17.
Para
Page
7.
10. Page 10, para 17.
Yes.
The Honorable High Court of Karnataka in the case of TT Limited versus R. Subramaniam and other reported in so has clearly laid down that any interim relief to be granted to the workman is only from or after the date on which the issue of validity of domestic inquiry is decided. In the present case, the Honorable Tribunal held the domestic inquiry as not fair and proper by order dated so and so. Hence, the order of the tribunal granting interim relief from the date of dismissal is incorrect. But this is only for the purpose of showing as to from when the interim relief can be granted.
Yes.
Nothing more. Therefore, my submission is, my lord, because the court has not considered my submission, the evidence before the court, the order is liable to be quashed. Oblige, my lord.
Yes.
How it makes big, huh?
Please for dictation. Day after tomorrow.
Oblige.
Yes, Mr. Sanjay. Class of whom? Notice has to go, or will you take notice? Take notice to I-1 of 2024 is filed to bring the LRs of this deceased respondent number 1 as respondent number 1A, 1A and B. Kindly corrected. It is 1-1. 1 A and B. So counsel MC Baswaraju undertakes to file power for the legal representatives of respondent number 1. At request, a week's time is granted. Learned counsel for the respondent has no objections to allow I1 of 2024. Reasons indicated is accepted. Application is allowed. I1 of 2024 is allowed. The legal heirs of respondent number 1 are permitted to come on record as respondent number 1 A and B. Petitioner to amend the cause title forthwith and file amended cause title within a week. Yes. Early hearing application is allowed. Raise the matter in court. No, 24 is allowed. Yes. Yes, Somshekhar.
Yes,
Is there
madam.
of settlement? KB Narayan Swamy submits that possibility of settlement talks.
It's going on, my lord, but it is not become fruitful. That's why I requested him.
It is not fruitful ಇಲ್ಲ ಅಂತ ಅವ್ರ ಕಡೆಯಿಂದ.
ಏನೋ ಮತ್ತೆ ಮಾಡೋಣ ಅಂದ್ರು ನಾನು ಹೇಳಿದ್ದೀನಿ, ಆಯ್ತು MD ಹತ್ರ ಮಾತಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ.
ಇದೇನು ವಾಟ್ ಇಸ್ ದಟ್ reinstatement?
Refusal of employment, during pendency, they have filed a memo, they are ready to reinstate these workers. Immediately they made them report it. Thereafter, after a few days, they were asked to report at the Tumkur. Until period be gradually put in. Thereafter, subsequently, the company has been closed. Oh, the person is only statutory benefits they are entitled.
ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರೆ ಮತ್ತೆ the counsel for the petitioner submits that there is a likelihood of settlement and as a final chance. List this matter on 9th to report settlement if any. And week after next. 17. This is extension of time. Get a stay in that writ appeal. How is this application? Petitioner counsel does not, respondent counsel does not press I number 2 of 2024. Accordingly, I 2 of 2024 is dismissed as not pressed. Please ask. Next. Yes, what is this application? What is the direction application? Who's filed this? We're not pressing because it's what has happened. We have already passed that order. This court has passed an order. No.
Actually, I given the statement for
You have filed a statement. By then it has already been decreased. No way, he doesn't want to press that I1. Petitioner counsel does not intend to press I1 of 2024. Accordingly, I1 of 2024 is dismissed as not pressed. Please the matter in preliminary hearing B group. Interim order granted earlier is extended to the next date of hearing. Stating the legality and correctness of the order passed by the respondent number one. Respondent number one, under section 25O of the Industrial Dispute Act 1947, ID Act for short. Granting permission to the respondent number two to close the factory. The Harley Workers Union, represented by its secretary, is before this court in this writ petition. Third, Learned Counsel case Subramanya, Learned Counsel for the petitioner, and CK Subramanya, Learned Counsel appearing for the respondent, and perused the material on record. Factual matter. The respondent number two is an industrial establishment. Commenced the production of biscuits and other confectionaries in the year 2001 at Tumkur Road, Bangalore. The petitioner union was formed and registered under the Trade Unions Act on 17/1/2011. The when was the union established? Union established when? Trade union was established when? Trade union. That is correct, right? The synopsis is correct? Correct. And the Charter of demands for revision of wages and other service conditions of the workmen was submitted to the second respondent. The second respondent tried to have a peaceful atmosphere of the factory. It is the case of the petitioner that the peaceful atmosphere was vitiated by issuing a notice changing the service condition of the workman by charging for carry bags, which used to be supplied free to the workman to carry the biscuits at a concessional rate once a month, without compliance with the section 9A of the ID Act. Further, the petitioner union addressed a letter in protest and demanded restoration of the original service condition of the workman, and that the management did not agree. The petitioner union approached the conciliation officer and on intervention the matter and resolve the issue. However, the efforts ended in a failure. And the Labor Commissioner and Conciliation Officer issued a notice of conciliation regarding lockout. the petitioner union gave a complaint to the secretary to the government labor department regarding violation of Section 9A of the ID Act and unfair labor practice by the second respondent. And no action have been initiated, second respondent. There was continuous protest by the workers and the factory was unable to function. And on 31/2013, on 6/6/2013, an application was filed under Section 25O of the Industrial Dispute under Section 25O(1) of the ID Act, enclosing an application in Form QA described under Rule 77C(1) of the Industrial Dispute Karnataka Rules 1957, read with Section 25O(2) of the ID Act, seeking the state government's permission to close down the factory. And the reasons leading for the decision to close is enumerated as under page 45. Page 45, para number 1, 2, 3, 4, 5, 6, 7, 8, 9. Para number 13. The reasons seeking for closure of the factory is the financial loss that has been suffered by the factory was beyond the powers and control, the law and order is not in the hands and the union is more than answerable for the situation, that the factory does not want to be in a situation where the interest of the general public will be hurt because explosive materials are stored and they have no control over the workers, functioning of the company bar factory is in the face of extensive damage to plant and machinery is beyond the ability and capacity of the management, and hence a request for permission to close the factory was genuine, and no other suitable or adequate measure is available to the factory. The workmen union filed objections to the application. The application. The factory had approached this court in WP. Five zero 56 or 5060 of 2013, seeking a writ of mandamus directing the police authorities to grant protection to the petitioner's factory and also facilitate for maintaining law and order inside the premises by evicting the workmen who are unauthorizedly assembling. This court disposed of the writ petition with the direction to the members of the union to obey the interim order passed by this court in MFA 1642 of 2012, dated 6/2/2012, in the letter and spirit. And made it clear that if there is any violation of an interim order in future, it is open for the petitioner to take such action as is open to him in law. By the impugned order, the respondent number 1 has allowed the application for permission of closure under section 25O, holding that after due and diligent inquiry, the permission to the factory is granted to close down their industrial undertaking with effect from 9/9/2013. Learned counsel for the petitioner submits and reiterating the writ petition, the amendments made in the writ petition would urge the following grounds: that subclause 2 of section 25O provides that the appropriate government, only after making an inquiry, if it thinks fit, and after affording a reasonable opportunity of being heard to the employer, the workman, and the person interested in such closure, may, and having regard to the genuineness and adequacy of the reasons stated by the employer, would grant such permission. The reliance is placed on the decision, on the following decision, otherly A and B. Orissa Textile and Steel Limited versus State of Orissa and others, AIR 2002 SC 708. Union of India versus Stump STUMPP. There are 2 of these synopsis. 3 of this. Versus Somappa Limited 1989 Part 2 LLJ 4. Lakshmi Starch Limited and others versus Kundra Factory Workers Union 1992 Lab 1C IC 1337. Maharashtra General Kamgar Union versus Wazir Class Works Limited and others 1998 Part 3 LLJ 231 Mumbai Bombay DON 6th. That the next, one night, you can catch, that the union was not granted reasonable opportunity and is in violation of section 25O, subclause 2. Emphasizing the same, Learned Counsel submits that the first respondent was, that hearing was held before the first respondent only on 24/7/2013, after which the matter was posted on to 1/8/2013 And despite the petitioner seeking for an earlier date, as period of 60 days would come to an end, no earlier date was granted. And in the hearing on 1/8/2013, the respondent management had filed its objections and the petitioner could not make their submission. And there was no opportunity to respond to the rejoinder of the management. And hence the reasonable opportunity as mandated under section 25O subclause 2 has not been provided to the petitioner. 3. The impugned order does not comply with section 25O of the Industrial Dispute Act 1947, as the respondent number 1 has failed to conduct any inquiry regarding the genuineness and adequacy of the reasons stated by the employer. That the order does not inquire regarding the genuineness and correctness of the facts, nor there is any findings given by the respondent number 1 regarding the statement. Next, that the conduct of the management was not considered when the management sought to seek for closure, order of closure, and that the respondent number 1 has failed to consider that the respondent number 2 was only trying to destroy the leadership of the union and remove permanent workmen and to entrust the whole work of factory to contractors. That the repercussions of the lives and livelihood of the workers and the result of closure was not considered by the respondent number 1 while passing the impugned order. Reliance is placed on the decision of National Textile (18 minutes) versus Union and others versus PR Ramakrishna and others 1983, Part 1 SSC 228. Stating this ground, learned counsel submits that the impugned order passed by the respondent number 1 takes away the livelihood and without consideration of the relevant aspects, there is a great impact on the workers. And the impugned orders is contrary to section 25O of the ID. For contra, the learned counsel appearing for the respondent illustrating the objections filed by the management would mainly contain the following grounds. One, industrial relations scenario from 2007 till 2010. Okay, that the industrial climate in the factory started deteriorating right from the year 2007 at the workmen at the instance of the union started agitating, disrupting the production. And the workmen had gone for strike for nearly 3.5 months from October 2007. The government, while referring the Charter of Demands for Adjudication, also prohibited the continuance of alleged lockout by order dated 18/24/12/2007, though the management did not declare any lockout. The prohibitory order issued by the government was quashed by this court in WP 384 of 2008, directing the union to give a collective undertaking to the management, assuring that they would maintain normal production and also maintain industrial discipline. That the union and the workmen did not keep up the undertaking given to the management after commencing the work from 11/2/2008. And the management had to face one or the other industrial unrestness right from 2008, and non-cooperation, cooperation, and non-attending to the allotted work by the office bearers of the union. Next. Industrial relations from 13/8/2011 to 27/9/2012. That on 13/8/2011, one of the workmen, Sri Honappa, had indulged in abusing and threatening the personal officer with dire consequences, and he was kept in suspension pending disciplinary inquiry. And on 17/8/2011, the workmen who were the office bearers of the union entered the production shop floor and stopped the production and caused extensive damage to the in-process material and production, and also the finished products, protesting the decision of the management to keep the above said workmen under suspension. That the workmen, after entering the factory and making their attendance to the system, did not attend their work in all the shifts. And the situation continued from 17/8/2011 to 20th August 2011. Industrial scenario from 28/9/2012 to 15/3/2013. That the absenteeism rate was increased and the acts amounted to, and the absenteeism rate increased. And some of the workmen were wearing rings, chains, threads, not maintaining good hygiene practices, and also were using mobile phones while working at the shop floor, and were indulging in several acts of defective packets, unfinished stock of crackjack inner packet generation was accumulating. Crackjack inner packet generation was accumulating. Union member workmen were deserting their work place and loitering in the premises. Discipline at shop floor was deteriorating day by day. The situation continued from 15/3/2013. The compelling reasons for declaring lockout made the management to declare lockout. And the management filed an application on 6/6/2013 seeking permission of the government under section 25O of the ID Act to close the factory due to the genuine and adequate reasons mentioned. It is submitted by the learned counsel that the management always wanted to have negotiation in respect of the charter of demands made submitted by the petitioner union. However, in spite of several sittings between the management and the union, there was continuous industrial unrestness. And though the management insisted the individual undertaking for maintaining proper discipline and decorum in the shop floor, insisting for such an undertaking would not amount to declaring a lockout. In spite of that, the behavior of the members of the union led to the management declaring a lockout, and that the petitioner had to approach this court seeking police protection for the activities that was conducted by the workmen in the factory. And this court had observed the existence and directed the petitioner, workers of the petitioner union to adhere or obey the interim order passed by this court in MFA 1642 of 2005. Learned counsel for the second response for the management submits taking the scope to section 25O of the ID Act, submits that the question of closure of an industrial unit would remain in force for a period of 1 year from the date of such order, and its finality is subject to the provisions of subsection 5, which in terms contemplates that the appropriate government may either on its own motion or an application made by the employer or any workman review its order made under subsection 2 or refer the matter to the tribunal for adjudication. Learned counsel for the petitioner respondent submits that the decision taken on the application for closure has been made operative for 1 year only. So after such period, if an employer still desires that the industrial unit should be closed, it may make a fresh application. The decision taken on the application for closure is operative only for 1 year. And the after expiry of 1 year from the date of allowing of the application order from the date of from the date of the order of respondent number 1. The date of respondent number 1. Next, the inquiry and procedure as contemplated under section 25O of the ID Act has been followed by the respondent number 1, and the impugned order does not warrant any interference in the present acts. Having heard the learned counsel for the parties, the point that arises for consideration is whether the opinion formed by the appropriate government is justified, and the closure ordered by the respondent number 1 is on following the procedure contemplated under section 25O of the ID Act warrants any interference in the present facts and circumstances of the case. Section 25O of the ID Act reads as under. Subsection 1 to section 25O envisages an employer intending to close an undertaking or an industrial establishment to which the chapter applies, is required to apply to the appropriate government in the prescribed manner for the permission to close down the establishment or undertaking within 90 days on which the closure has become effective. Employer is required to state the reasons for the intended closure in the application and serve the copy of the application on the representatives of the workman in the prescribed manner. Rule 76C subclause 2 prescribes that an application under this section shall be in Form QB, while Subrule 3 requires the application to be made in triplicate, and Subrule 4 enjoins the employer to furnish this to the central government such further information as the government may consider necessary and call from him for arriving at the decision on the application. Subsection 2 of section 25O envisages that the appropriate government is vested with the discretion to grant permission to the employer to close its undertaking. But before granting or refusing the permission, the government is required to 1. To make necessary inquiry into the facts and circumstances of the case, as it may think fit necessary, semicolon. 2. Roman 2. Give reasonable opportunity of being heard. Additionally, A, to the employer, B, the workman, and C, the persons interested in such closure. Roman 3, considered. A, genuineness and adequacy of the reasons for the closure stated by their employer. B, the interest of general public. C, other relevant factors. 4, Roman 4, pass an order in writing or refusing to grant permission applied for, stating the reasons therein for grant or refusal to grant permission, and communicate the order to the employer and the workman. Are the four others. 4, 5. Subsection 3 of Section 25O envisages that on an application made by the employer seeking permission for closure, the government does not pass any order within 16 days, resulting in the deemed grant of permission to close down the undertaking. Subsection 5 of Section 25O envisages review or adjudication of the order passed by the appropriate government. This provision vests twofold power on the appropriate government. A, itself to review, suo moto, or an application made by the employer or any workman, its order granting or refusing to grant permission under subsection 1, and B, to refer the question of granting or refusing permission to an industrial tribunal for adjudication. Subsection 6 states about the consequences of closure without permission, which is not relevant for the adjudication of the present dispute. Section 7 and 8 is a power, subsection 7 and 8 is a power to exempt and compensation, which corresponds to subsection 1 of Section 25FF. From the above provision stated under Section 25O, the present facts of the case needs to be looked into as to whether the appropriate government has followed the procedure as contemplated under 25O for granting permission to respondent number 1 to close the fund. The perusal of the impugned order, the respondent number 1 has framed the following issue for consideration. Para 40. While answering issue number 1, the respondent number 1 held that the management bar factory has followed the procedures laid down under Section 25O of the ID Act, read with Rule 77C, Bar 1 of the Karnataka Rules 1957. And while answering issue number 2, it held that the copy of the application was served on the representative of workmen. The issue number 3 was regarding the genuineness and adequacy of the reasons stated for seeking foreclosure. The principal issue before the respondent number 1 was whether the workmen, management, and the interested persons concerns were heard, and whether an inquiry regarding the genuineness and adequacy of the reasons stated by the employer was considered. The material on record would indicate that the petitioner union was heard and the impugned order was passed. The genuineness and adequacy of the reasons stated by the employer bar factory was the frequent strikes, stay in strikes, loss of man hours, resulting in the loss in the production, causing huge loss and efforts to the establishment. The respondent number 1 has duly considered the genuineness and adequacy of the reasons stated by the factory management seeking for closure. The bona fide, which is one of the essential factors while considering 25O of the Act. Was not one reason, but from 2007 to 2013, and also there was a dispute regarding the lockout. Complaint was lodged. The persistence on part of the union made the respondent factory seeking for closure. The decisions placed by the petitioner counsel court has absolutely no quarrel to the settled proposition of law. But in the circumstances which the reliance is placed, the genuine inverted comma, and adequate reasons which was occurring in 25O subclause 2, which is of great importance, was not available in those decisions. And in that circumstances, the lack of bona fides and loss of employment, the decision is not applicable to the present matters. In the case of Wazir Glass Works Limited, Alandra Maharashtra, AIR 1996 SC, to our judgments and Senate Counsel for the respondent has placed reliance on the following decision. AIR 1996 SC 1282, Wazir Glass Works Limited versus Maharashtra General Kamgar Union and another Maharashtra Kamgar Union. Wazir Glass Works 2009 Part 3 LLJ 275 Britannia Industries 2003 Part 2 LLJ IL Naidu. The apex court in the case of Wazir Glass Works Limited has held at Paranam has held that whenever an application for closure of an industrial unit is made by an employer, the state government before whom such an application is made is required to dispose of such application within 60 days from the date of making the application and communicate its decision with the set period of 60 days so that the employer does not suffer any hardship on account or failure on part of the state government to dispose of the application for permission for closure expeditious. Further held that review by the state government of its decision on the application for closure, either on its own motion or on the basis of the application to be made by the aggrieved party. Further, that the decision taken on the application for closure has been made operative for 1 year only so that after such period, if an employer still desires that the industrial unit should be closed, it may make a fresh application for permission to close the said unit. It further held that the scheme of 25O, the review application is to be made before expiry of the said time frame of 1 year. And such application is to be disposed of within such time frame, otherwise such review application will become infructuous. The full stop. The argument that a party should not be made to suffer simply on account of the failure on part of the statutory authority to dispose of a review application within a time frame and thereby rendering it infructuous, is not tenable, because the expiry of the said time frame of 1 year, the party aggrieved has a right to make a fresh application by incorporating all material facts german for consideration of the application for permission to close, including the factors indicated in the review application. Further, it held that the state government would cease to have jurisdiction to review its own order on the application for closure of industrial unit after expiry of 1 year from the date of rejection of the application for permission to close is correct. The apex court in the case of Britannia Industries Limited held at para number 14 as under 14, 17, and 19 as under. Twenty, 28. The management has filed application under section 25O of the ID Act seeking for permission for closing the factory with effect from 6/6/2013. After hearing the petitioner union and the employer and finding union, inquiry regarding the genuineness and adequacy of the reasons stated by the employer and feeling it substantially and adequately proved beyond doubt the intention of the employer not to be in the business and suffer further financial loss. The industrial unrest in the unit. The respondent number 1 has rightly allowed the application and accordingly the point framed for consideration is answered in favor of the respondent management. And this court passed the following order. The petition is dismissed. The impugned order passed by the respondent number 1. That's done. Anything else? Order first. We'll recall that order. Dismiss for default for the reasons indicated in the application. The order dated 12/7/2024 is allowed. Petition is restored to file. Order sheet. Without mentioning the names. Is Mr. Somshekhar?
Number 23.
Not sir.
23, my lord.
Ah, yes.
The petitioner, my lords, your lordship
Yes,
has
yes.
heard me with regard to this joint negotiation committee,
Ah,
with regard to the formation of the joint negotiation committee,
hmm.
where, my lords,
Clause 4, right?
clause 4, my lords, where for the 7th position,
Ah,
then a clause was made
hmm.
under which even if it is less than the provision which required for this thing, they said, all right, we will take it up and we will do it. Now, my lord, a settlement was very clear, which you may, lordship may kindly take to clause 4, where clause 4, my lords,
Yes, yes.
where it says the JNC, that is Joint Negotiation Committee, will have only 7 representatives representing labor and such representations by unions, securing more than 15% votes at the rate of 1 representative for every 15% votes polled. Last, that is 7th seat, will be given to the union having residual votes less than 15% subject to a minimum of 10% and
Yes.
which has the highest in the residual list. One of the 7 representatives of the Joint Negotiation Committee will be its chairman, be elected by the committee.
Yes.
Then, my lord, the elections were held. The Assistant Labour Commissioner held the elections.
Ah,
Then he gave the he submitted the list, my lord. Your lordship gets that at page 100 and he gave the names of 4 of them because only 4 of them had got from the same union. That is,
Page
my lord's
number?
list. At page 30. Page 30 may kindly be seen here.
page 3.
Page 30. Your lordship get the results. The elections were held by returning officer, who is the Assistant Labour Commissioner, appointed by the Commissioner of Labour. Now, after holding elections, he has given this result, in which he says, Dandeli Karmikara Sangha Dandeli votes 335, 12.67. Then Dandeli Paper Mills Navkarara Sangha 189, 7.15%. Karmika Sena Dandeli 66.82%. Now,
Yes.
15 into 4. So 4 representatives were elected and as reported, by the returning officer.
Yes.
Now, the rest of them, they got less than 15%.
Ah.
Now, what is happening is, the first one, Dandeli Karmikara Sangha, that is saying, I got more than 10%, less than 15%, therefore I should have been also selected for the joint negotiation committee.
Ah.
The contention of the management all through has been, look here, it is only for the fifth position that it is agreed. If it is between 10 and 15 also, for the fifth position, it is not agreed. The seventh position only, as per clause 4.
Yes.
Your Lordship may kindly see the clause 4 again. It refers only to the seventh position.
Ah. Ah.
Therefore, the management said, and even the returning officer said, sorry, and he directed only 4 of them to be the members of the committee.
Yes.
Now, this union approached the government
Ah.
and sought for permission to prosecute the management for violation of, and that your Lordship gets at page 101.
Yes. Ah.
Your Lordship will see at 101, an application was made under section 39
Yes.
by the President Dandeli Karmikara Sangha.
Ah.
Now, your Lordship may take to page 101C.
Yes.
In fact, your Lordship may even see at page 25, my lords. They have extract of the votes polled has been given. Below that, on the basis of the percentage of votes secured, Karmika Sena has obtained 4 seats. Dandeli Karmika Sangha Dandeli have alleged that even though they had secured more than 10% of the residual votes, that is 12.67%, their Karmika Sangha has not been given 1 seat by the election officer. It's not a complaint against me, by the election officer in terms of condition 4 of the agreement. And the same is clear violation of the terms of the agreement dated 3/4/1991. May I stop here for a moment?
Yes.
The allegation is against the election officer. Because I have no role to play. I can't select anybody. The election officer was Assistant Labour Commissioner. He gave the report. Even otherwise, he says under section 4 or clause 4, he should get. For that, may I proceed further? They have further stated that in the referendum, Karmika Sangha secured 66.81% of the vote, and as per the agreement, 4 seats have been provided to them at 1 seat for every 15% vote secured, for which they do not have any objection, as the same is in accordance with the agreement dated 3/4/1991. However, with respect to the balance 32.83 residual vote, only Dandeli Karmika Sangha has secured 12.67% of the vote, and in terms of the provisions of the agreement dated 3/4/1991, Dandeli Karmika Sangha is entitled for 1 seat. More importantly, there are 2 issues, that is, out of the balance residual vote, higher votes have been secured than all other employees unions, and higher percentage of votes, that is more than minimum 10% prescribed, has been secured. In view of both these reasons, and in terms of the agreement, they have stated that Dandeli Karmika Sangha is entitled for securing 1 seat in the joint negotiation. Now, bloods, this is the whole case, blood, and the authority just follows whatever has been said and passes an order. Your Lordship may see. Kindly see, my lord, at page 101M. Last paragraph at 101M. Lordship gets that, my lords?
Yes.
On careful scrutiny of the above provision, it is seen that the agreement has provided for selecting a maximum of 7 representatives, and the selection of the 7th representative has been detailed in the provision after selection of 6 representatives, that is, in terms of the agreement. A maximum of 7 representatives can be selected. Presently, one union has secured 66.81 votes, and it has elected 4 representatives. Out of the balance 33.19 residual votes, the Dandeli Karmika Sangha has secured 12.67% votes and has complied with the agreement provisions of securing more than 10% of the residual vote and also higher votes than all the remaining employee union. In terms of the agreement, a maximum of 7 representatives can be elected, but it cannot be said that this provision does not apply in cases where the less than 6 seats has been obtained. If any union secures more votes than the other union out of the residual votes, it is entitled for securing 1 representative seat, and if this is denied, the same would amount to tantamount, the said union be deprived of a seat, even though it has secured the stipulated percentage votes in terms of the agreement.
Yes.
This is the officers, finally order portion at 101Q.
Yes.
The violation, the condition for the agreement entered into on 3/4/891 by the management of West Coast Paper Mill, Bangalore, Dandeli, does not amount tantamount to violation of section 17A so and so, but is also punishable under section 29 of the Act. And permission is hereby granted to the President, Dandeli Karmika Sangha, Dandeli Vishwa Sharma Chetana, Basaveshwar Nagara, Gokul Road, Hubli, to initiate legal proceeding with the management of West Coast Paper Mill Limited, Bangur Nagar, Dandeli, Aliya Taluk, Uttar Karnataka district before the competent court. Now, my submission is, I never declared who got elected. It was the returning officer who declared 4 people as elected. And he has rightly gone by clause 4, which says only for the 7th seat, it could be less than 15%, but it should be 10% or more. Now, how do you prosecute me? I am not the deciding officer at all. Even otherwise, but this is for such a long period. This was sometime very, very old, Mila. Even the order is dated. The settlement was entered into in 91. Now almost 33 years, and the order passed is dated 16, which is again more than 8 years. 3 more settlements have been signed. 3 more negotiating committees have been elected. Now, what is the significance of prosecuting me?
Yes.
When I am not in the picture at all, because the election was conducted by the Assistant Labour Commissioner on an order passed by the Labour Commissioner. He announced the results. If at all they have any grievance, they should go against the Assistant Labour Commissioner who was the returning officer. In what way I am concerned? Why should I be prosecuted?
Sure.
That's right.
Failing the legality and correctness of the order passed by order dated 14/6/2016, passed by the first respondent, Labour Commissioner, at annexure R. According permission to the President, Dandeli Karmika Sangha, that / Dandeli Vishwa Ashrama Chetana, to initiate legal proceedings against the management SS West Coast Paper Mills Limited. The management is before the court. It is the petition. Third, the learned senior counsel S.N. Murthy for the petitioner. Though the matter is listed for further hearing today, there is no representation on behalf of H.K. Nagarabhushan, learned counsel for the respondent. And the matter is the judgment, the material on records are produced. The trade union who were operating in the year 1991, which included respondents 2, 5, and 6, and the petitioner and the management entered into a settlement dated 3/4/1991. The settlement pertained to the deciding the representatives of the union through conducting of secret ballot for the joint negotiating committee. It was agreed that the returning officer would be appointed by the Commissioner of Labor and Work on joint request of the petitioner management and trade union. The clause 4 of the settlement reads as under page 5. Clause 4. The learned counsel for the petitioner, learned senior counsel for the petitioner submits that the returning officer after holding the election, who was appointed by the first respondent, conducted the elections and announced the result as per Annexure E. As per Annexure E. And that the petitioner had absolutely no role to play in the entire election process. Whether the results were announced in terms of clause 4 of the settlement dated 3/4/1991 or otherwise is not it is not for the petitioner in question, as the election returning officer has conducted the elections and announced the results. The Labor Commissioner, respondent number 1, without considering that the election process or the manner in which it was conducted, or whether there was any violation of clause 4 of the settlement dated 3/4/1991 by the petitioner, has sanctioned prosecution to the petitioner, assuming that there is a violation of clause 4 of the settlement dated 3/4/1991 by the petitioner management. The next one, 2. The Labor Commissioner has not correctly appreciated the scope of clause 4 of the settlement, even otherwise, as merely because the second respondent has secured more than 10% votes, a representation in the joint negotiation committee cannot be given to it, as 15% of the votes are required for getting a representation. And it is only for the 7th place that 10% or more of the votes polled will entitle a union to have one representative in the joint negotiation committee. And the commissioner, respondent number 1, has wrongly arrived at a conclusion that the management has failed to give representation to the union, which obtained highest residual value and thereby violated clause 4 of the settlement. Next one. The point that calls for consideration is whether the Labor Commissioner, respondent number 1, was justified in according permission of sanction to prosecute in the present facts and circumstances of the case. As stated supra, clause 4 of the agreement dated 3/4/1991 is that the JNC will have only 7 representatives representing the labor, and such representation by union securing more than 15% vote at the rate of 1 representative for every 15% votes polled comma, last, that is, seventh seat will be given to the union having residual votes less than 15%, subject to a minimum of 10%, and which has the highest in the residual list. Comma, one of the seven representatives of the joint negotiating committee will be its chairman to be elected by the committee. The returning officer who was appointed by the first respondent conducted elections and announced the result, indicating as under result and page number 30. The results and the entire election process was conducted by the returning officer, as is evident from the material and records. The respondent number 1, while passing the impugned order, has observed that the Karmika Sangha has not been given one seat by the election officer, underline model, election officer, in terms of clause 4 of the agreement. And the same is clear violation of the terms of agreement dated 3/4/1991. The Labor Code goes on an assumption that the violation of clause 4 of the settlement is by the petitioner management, who was nowhere involved in the conduct of election and the order passed by the first respondent, Labor Commissioner, granting permission to the respondent number 2 to prosecute the petitioner is without application of money. The prosecution is a serious matter, and sanction of prosecution cannot be given by merely asking the sanctioning authority, while sanctioning prosecution should go into the entire matter and to satisfy himself whether a prima facie case has been made out and there exists for granting a sanction for prosecution. The contention of the respondent in seeking permission to prosecute is that it had secured more than 10% votes of the votes polled. And as such, one member of the union should have been approved to be negotiating committee in terms of clause 4 of settlement dated 3/4/1991. The respondent number 2 has not made out any violation of clause number 4 of the agreement dated 3/4/1991 entered into the employees union and the management, and violation by the management. The respondent number 1 has, without an application of mind and on the presumption that the management could have declared one person as elected and take them to the negotiating committee has come to a wrong conclusion and granted permission to prosecute. The impugned order passed by the respondent number 1 warrants interference by this court, and the point framed for consideration is answered in favor of the petitioner management. And this court passed the following order. The writ petition is allowed. The impugned order passed by the respondent number 1 at an extra R is hereby set aside, and consequently, if any proceedings have been initiated by the respondent union, the same is also would not survive consideration.
Blind Miller's.
Abstain. Yes.
Number 24.
Yes. Sikta nimge ಏನರೆ. It is available. See, this will give you in this judgment also, which you place reliance. Adrelli. In that they say, but it is made clear that it is only to the pay scale. Pay scale. It's whether the other benefits would be made available to them. Yes. First thing, industrial dispute, would it be maintainable now before the labor court? And in light of such prayers?
What are the matters are there? If I only judgment, ask that. I do in detail, what are the increases and what are the powers the tribunal has got? Tribunal has got not only to interpret a contract of employment between the person employed, they also can add or alter the contract.
Correct, that's correct.
So, even if I just example, if I want to make a demand, the employee that I would like to have, then there was this one. The management says I will not give it. So when exactly that matter.
For that pay scale and all that has now been.
But there is a chart of demands for the employee. The chart of demands will not contain only my pay scale cover. It has so many other factors also will be. The concerned industrial tribunal considers each and every demand whatever I have placed. Whether it is applicable, reliable, or the same industrial standard, everything is considered. Even in my case, for that, I have placed certain demands, especially on time home, on the earned leave and cash, and other such type of demands are placed before me. Because before consideration, they did not participate in consideration. Finally, it went before the time. Tribunal has taken into consideration all the parameters, including government orders. In what parameters, in what basis you are going to go? Then I say that there are different government orders are there, which are like applicable to government services. I am also performing the same simulation. As it is the establishment has
You have to establish that the benefits what you have claimed from an unaided institution, this unaided institution has to be in par with the government employees or the government circular.
Yes. As it is, it's very clearly mentioned, it's also very clearly stated that the nature of job which are performed and the nature of institute which are undertaken, and also the base which is given to the government servants are same and similar. For example, if the 6th pay commission is extended to me, what does it mean?
I am also performing the same supervision of law. With the exemption of activity, they are also providing this commission to me. Because if at all I was not performing the same and similar type of job, which is 60 commission is being extended to any of the government service of the education institution, then there will not be what you can extend the benefit to me for that fact. So, since I am admitted to the fact that I am eligible and they are also eligible for the pay commission as per the pay commission. I in regional parameter, I am also entitled for benefits which are given to the other class of employees for performing same and similar nature of job. This is nothing but equity and parity as well as equality, which is very much within the purview of the.
Yes.
That's all. And even that's what Secretary Mahatma Gandhi has given very clearly. Let us also understand your watch. Whether there is any such government rules are that pay scale should be given to me also. Yes, definitely there are government rules. The 1978 what is referring to? There was a act earlier, it was the 1975 Act. That only got repealed and it became 1983 Act. In 1975 Act for that particular. Section 5 of the Act is applicable to all the
Education Act.
Karnataka state education system.
Yes. Nineteen
1990.
that has become 83, Alva. That is
78. 78.
ಇದೆ ಎಷ್ಟು 77.
Now, equal to 1987 has come up 1986.
Which is the act which is applicable now? Karnataka Education Act.
But Karnataka Education Act 1983.
Ah.
I am not coming to that act. I am
then-
only talking about 1978 rules.
Which is that rules, no? 78 rules. No?
What actually I have done, just give me. Similar matter was covered, was also heard by the only culture for it. This aspect was really in detail, only. That was second pertaining to homeopathic medical colleges. Worker of AMC homeopathic. The detailed analysis was what actually was the earlier act, more exactly the subsequent act came to be, and whether we have got a similar type of rules for the unaided institutions. This has been answered in detail because 1978 rules is very much applicable to me. And into page 20, paragraph 76.
19, no?
Oh, I see.
What was the facts in this case?
The fact is that pay scale.
Pay scale.
Pay scale.
So pay scale, we have no dispute now. Alva, pay scale.
Yeah. Basically, which is applicable to government service is also. Definitely, the benefit which are given other
Yes.
is no reason why it's not going to. If not, we don't have any such rules of giving extension of
Then all-
cash credit or the time bound promotion.
What is the difference now between this private education institution unaided and the government institution? Then what would be the difference that would be there? What would be the difference? Somebody.
Only difference.
Why?
Government employees, the money is being public concern fund of public government.
ಅಷ್ಟೇ ಇರೋದು.
Whereas, private institution, they have not about the regulation of it, they have covered. That's only difference. Otherwise, I cannot be treated unequally. Because it's also against the provision of
Let him complete it. What is that you want to make?
So there is time bomb rules, it says that it will be applicable to all government entities.
Yes, we will hear you. According.
So the only difference again, they are paying from the government fund, I am paying from the fund which is collected by way of fees.
Then nobody will, now all will come to private undertaking only. Nobody will go for government.
Because there's a very policy or the budget. But we also not understand that what is this whole concept of the regime?
Title commencement and application. This is called Karnataka Civil Rules, time of advancement rules 1988. They shall come into force on the date of their publication in the official gazette. They shall apply to all government servants found by the Karnataka Civil Service. Except person whose appointments are made according to any contract unless the terms are the first. Person appointed as person appointed as local consolidated pay on not part-time basis and government servants are according to the applicable to only government employees, not to them. And madam, with respect
Yes. We'll continue in the afternoon. We'll continue in the afternoon. Yes, after you come, we will take this. Yes. You appear for, your Bala Subramanya. And so concert 6 times. Was this matter heard? Was it heard by this court? No. Bala Subramanya came, then it counsel. Is this matter? When do you want? State. 10th. ಇಲ್ಲ ಅದಾದ್ಮೇಲೆ ಕೊಡಿ
17.
17. See, we call this matters, right? The first hour. Now the senior one age person asks some time. You're too young to ask the time at 1:30, right? And this is a 2013 petition. Is it not? What is your justification for seeking time now in this? Could make this mention in the morning now. 30 at request of the petitioner counsel. This matter week after next as a last chance.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಏನಾದ್ರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದೆಯಾ ಸರ್? ಮೇಡಮ್ 25 ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ನಾನು R7ಗೆ
25 ಇದೆ ಸರ್.
ಇದೆ ಅಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಲ್ಲ?
ಇದೆ.
ರೈಟ್ ಓಕೆ ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
Oh,
Number 25. This is A.
on ground by all councils that they are not well.
I'm for R7 in the matter.
Huh?
I'm for respondent number 7, my lord.
What is? Huh. Yes, when do you want? ನೀವು ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ because we have given a specific date. You have to tell the date of your convenience. And on, release this matter on Monday at request of joint council on the ground that Bipin Hegde, learned counsel, is unwell. Vinod Kumar, arguing counsel Vinod Kumar is unwell. Yes. Based under the caption further hearing. Yes.
Please.
They are taking time. Yes. Yes, Mr. Natraj Ballal. Sir. Sir. Sir.
32. In Muralidhar Peshwa.
Sir.
33. Gaurav Vivek.
Yes, madam. Where is he? At request of SCGP, release this matter tomorrow.
Then number 34. Ramanya Patel.
Password.
35. Mrs. Sitaram Rao.
The KVO matter. Mr. Sitaram Rao. Passover. You have the records now, or you have to say. SCGP to secure the records. List this matter on Wednesday.
Fraternity.
Is Mr. Harish Bhandari. ಏನಿದು? Acceptance, huh? The resignation was held not to be voluntary, na? What was it held by the labor court? 1 month note. Resignation. Oh. Now he's working. He's working. Attend superannuation. Page. Circularly. Annexure C, na? Yes. What does the circular say? An employee intending to resign from the post held by him should give a notice of his intention to resign at least in advance, indicating the date from which he intends to resign. The company will accept the notice of less than 1 month if there is a circumstances warranting such acceptance. Circular is at annexure G, page 54, 5. Circular 793 is there. Page. Ah. The resignation was not accepted here. Ah. Ah.
Within 2 days, they accept the resignation. As per this circular, they have to have wait for 1 month. It is therefore necessary to see that handing over that for a from the employee before the employees are relieved of.
1 month notice in advance is to be given by the employee.
Not they have to cover 1 month wages.
ಹೌದು.
Some circumstances warranting.
Warranty.
Circumstances warranting and actually explained in order of acceptance. This is not declared by the Islamic court and actually extracted by the labor court.
When did he give his resignation?
2010.
10/3/2010. And when was it accepted? 12/3/2010.
23/3/2010.
Except Admal withdrawal.
They have to wait 1 month.
Then you say after he submits his resignation, if after acceptance they have to wait for again 1 month.
That 1 month salary.
Yeah, 1 month. It is from 10/3 to 12/3. 10/3 to 10.
2 days.
2 days. And then he is not. When did he give his withdrawal?
23/3/2010.
So that the notice has to be waiting period of 1 month. Yes. Ellie? Yes. No. Expectation ಇದೆಯಾ? For what? ಎಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ ಪ್ಯಾರಾ? ಹಾ ಹಾ annexure A para number 7. 7 is internal page or 22, huh? Huh.
Self-known that is what is the layer of all class C. Carry them more, not so the getting salary. All time, takes. If there are circumstances warranting acceptance, as pointed out by the not be able to see it.
What are the circumstances warranting here? What are the circumstances warranting?
And not to explain.
What would be the circumstances that would warrant? Under what circumstances? Ah.
Four results are stated in the related 8 report. Accepting the declaration of something immediate signature. I do not see any reason to uphold matter of the direction stated above. Clearly, we can follow. Follow the procedure. Only we got to condition of the union council for a document and that can be made between last PLC, all PLC to get together. Last PLC talks about the decisions is normally accepted in the least possible delay, except in certain type of cases and last week, provides for procedure to be followed. The both project PLC are great together. I do not see no immediately and the absence of the circumstances warranting so that applicant authority can accept a notice of abandonment if there are circumstances warranting. If the issue, other acceptance signation should be reminded. Note the reason for acceptance signation. Otherwise, not able to accept the system has for the elimination. Application has been tendered by the markets. Suppliers have waited for accepting it. There are compelling circumstances warranting Preparation could have indicated, then in the order of both observed in this case. As such, if you order at 1894, stands aside. Since so,
Where is the order passed by the management of the corporation accepting the resignation? What is the circumstances it has been narrated? Is the latest 2010 beda. Page number?
This is the resignation second time. ಆದ್ದರಿಂದ ನಾನು ಸೇವೆಗೆ ಮುಂದುವರಿಯಲು ಸೆಕೆಂಡ್ ಟೈಮ್ ಇಷ್ಟವಿಲ್ಲದಿರುವುದರಿಂದ ನನ್ನ ಕೆಲಸಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡುತ್ತಿದ್ದೇನೆ. ದಯವಿಟ್ಟು ಈ ಮನವಿಯನ್ನು ರಾಜೀನಾಮೆಯನ್ನೇ ನನ್ನ ಮನವಿಗೆ ರಾಜೀನಾಮೆ ಪತ್ರವನ್ನು ಪರಿಗಣನೆ ತೆಗೆದುಕೊಂಡು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತಹ ಸೇವೆ ಮುಕ್ತಗೊಳಿಸಲು ನನ್ನ ಸೇವೆಗೆ ಅಂತಿಮ ಅಭ್ಯರ್ಥಿಯನ್ನು ನೀಡಬೇಕೆಂದು ಕೋರುತ್ತೇನೆ.
According to you, ತಕ್ಷಣದಿಂದ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ
P1 ಏನ್ ಮಾಡ್ತಾರೆ ಇಮಿಡಿಯೇಟ್ ಎಫೆಕ್ಟ್ ಕೊಡ್ಬೇಕಿದ್ರೆ ಅದು ಒಂದು ಪ್ರೊವಿಷನ್ ಇದೆ. ಈ ವಿಶೇಷ ಚಾಲಕ ಆಗ ನಾನು 8/3/2010 ನನ್ನ ಕರ್ತವ್ಯಕ್ಕೆ ವೈಯಕ್ತಿಕ ಕಾರಣದಿಂದ ರಾಜೀನಾಮೆ ನೀಡುತ್ತೇನೆ. ಅದಕ್ಕಾಗಿ ಸಂಸ್ಥೆಯ ಸುತ್ತೋಲೆ ಎನ್ನುವ 10,000 ಪಾವತಿಸಲು ಅನುಮತಿ ನೀಡಬೇಕಾಗಿ.
So he's paying his 1 month salary. 1 month salary. Immediate the circular that 10,000 put there, immediate you would be accepted and where is that circular to that effect that on payment of 10,000 his resignation would be immediately accepted? ಇದೆಯಾ ಸರ್ಕ್ಯುಲರ್ ಅದು? ಎಕ್ಸಿಬಿಟ್ ಇದೆಯಾ ಅದು? This month 20th 5 or 26 5 ಓದಿ ಅದನ್ನ 25 ಓದಿ. Paragraph 1 ಓದಿ. ಸಬ್ಕ್ಲಾಸ್ 1 ಓದಿ. ಸಬ್ಕ್ಲಾಸ್ ಸಂಸ್ಥೆಯಲ್ಲಿ
ಯಾವುದೇ ಕಾರಣದಿಂದಾಗಿ ಯಾವುದೇ ಕಾರಣಗಳಿಂದ ರಾಜೀನಾಮೆ ನೀಡಬಯಸಿದರೆ ಸಂಸ್ಥೆಗೆ 10,000 ಮಾತ್ರ ಏನು ತಿಳಿಸಬೇಕು ತಮ್ಮ ಹುದ್ದೆಗೆ ಸಲ್ಲಿಸಿದ ರಾಜೀನಾಮೆಯನ್ನು ನೀಡಬೇಕು ಉಚಿತವಾಗಿ ಅವರ ವಿರುದ್ಧ ಯಾವುದೇ
ಅಲ್ಲ, ಅವ್ರು ಇಮಿಡಿಯೇಟ್ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿ 10,000 ಅಲ್ಲ, ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ರೆ whoever opts for this resignation.
Now they have to recover 1 month salary, then 1 month they have to wait. It's a lot of requirement.
ಅದು 10,000 ಇಮಿಡಿಯೇಟ್ ಅಂತ ಇಲ್ಲ ಅಲ್ವಾ? ಯಾವುದೇ ಕಾರಣ, any resignation, he has to deposit a sum of rupees 10,000. Special circumstances ಹೇಳಲ್ಲ.
This is your second resignation he has submitted. Second resignation. Now, your worship, we have not compelled him to give such resignations. Now waiting for period of 30 days, your worship. Yes, once he has withdrawn the first resignation, having withdrawn such resignation, he is very much aware that he is going to second resignation on his, well, in more mention. It's a voluntary act by him.
Correct. We must have given first resignation 2010 ನಲ್ಲಿ ಕೊಟ್ಟ. I mean, this was given in the year 2000. Immediately, na? First ever ಕೊಟ್ರ?
This was withdrawn in the lawsuit. ನನ್ನ ಕುಟುಂಬ ಸಂಸ್ಥೆ ಸರಿಯಾದ ಕಾರಣ ನಾನು ರಾಜೀನಾಮೆ ಪತ್ರವನ್ನು
2010 ನಲ್ಲಿ ಕೊಟ್ಟ. On 31/2010 he submitted to withdraw. You had not accepted then. ಅವಾಗ accept ಮಾಡಿರ್ಲಿಲ್ಲ. ಆಯ್ತು, 1 ತಿಂಗಳು ವೇಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
accept ಮಾಡಿದ್ವಿ ಫಸ್ಟ್ ಇಂದಲೇ.
ಹೌದು, ಸೆಕೆಂಡ್ ನಲ್ಲಿ on that he is already superannuated ಅಲ್ಲ.
Permission also calls this.
This is that. Very correct. Is para? Para ಇಲ್ಲ. Continue. Yes.
Evaluation. The labor court came to the conclusion that the letter of proceedings on the 15th and not on 19th of March of the year, and then this state had been accepted by the competent authority, same as necessary authority on 19th March, said, by waiver of the notice period. Plus, further held that resignation having been accepted, purported withdrawal of the same on 20th was totally inconsequential. And effect as the employee was voluntary act and itself is not of service. Put an end to his service under the employment. The argument that the resignation could have take effect only from the date of notice period to expire was repelled by the date of court. For the employer had the discretion to hear the service of the notice, and if the letter of decision did not say that the same should be effective from the future date, the acceptance of same put an immediate end to the relationship with the employee. The reference was accordingly rejected with the reference awarded. This is the case for us.
This is the
Yes, that's it. But we just immediate effect of our record. Seven.
The proposition, the proposition that a resignation.
The resignation not by persons same before has become effective cannot be disputed. The question, however, is whether the resignation in the instant case was meant to be effective on the intended or on the end of the person in the employee present. The plain reading of the letter of the resignation is submitted with no kind of doubt that this was not meant to be as was position of the case is relied upon by the
ಅಲ್ಲ ಇದರಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಏನಂದ್ರ ಶೇಖರ್ ಅವರ he gives a resignation. He says, please take this resignation forthwith. ಹೀಗೆ ತಗೊಳ್ಳಿ, ನನಗೆ effect ಹೀಗೆ ಕೊಡಿ ಅಂತ. What can the management do then? Corporation has to accept it. ಅಲ್ವಾ?
Last stage of curriculum. They have to have
In normal circumstances, if you would have just given a resignation and said, please accept my resignation, they had to wait for 1 month. But now when the employee himself states, beda, please accept my resignation. ಅಲ್ಲ ಈಗ ಫ್ಯೂಚರ್ ಡೇಟ್ ಅಂತ ಏನಿಲ್ಲ. ಅದೇ ಅಷ್ಟೇ ತಕ್ಷಣ ಅಂತ ಏನ್ ಹೇಳ್ತಾನಲ್ಲ, ನೀವು ತಕ್ಷಣ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೂ ಒಂದ್ ಮಾತು ಹೇಳ್ತೀರಾ. This was the circumstances where the regulation happened. ಇದರಲ್ಲಿ ಏನಿತ್ತು circumstances? Before attempting to commit suicide, seems to have submitted a resignation. Was C important?
Procedure to be followed in acceptance of delay. An employee intending to post held by him should give the notice of intention to resignation. Take a month that once indicating the date from which he intends to resign.
Well, in this case, was there a notice? Was there the resignation given by the workman stating that he should be relieved from his job immediately and retirement? Idrali, he said, accept my resignation forthwith. Idrali, nim case. Intent.
Therefore, we have to express from which date I was
intent to resign ಅಂದ್ರೆ immediately ಅಂದ್ರೆ ಇವತ್ತಿನ ದಿವಸ ನಾನು ಯಾವಾಗ ಕೊಡ್ತೀನಿ ಅವಾಗ. ಕರೆಕ್ಟ್, ಅದೇ ಅದರಲ್ಲಿ ಸರ್ಕ್ಯುಲರ್ ನಲ್ಲಿನೇ ಹೇಳ್ತದೆ ನೋಟಿಸ್ ಆಫ್ ಹಿಸ್ ಇಂಟೆನ್ಷನ್. ಅಲ್ಲ ಇದು ಒಂದು ಓದಿ ಇನ್ನೊಂದ್ಸಲ, ಸಿ ಓದಿ. This is very important. This is very important. Alva, this is very important. Which he intends to resign. It's not.
application.
ತಕ್ಷಣ ಅಂದ್ಮೇಲೆ
ತಕ್ಷಣ ಅಂತಂದ್ರೆ they have to follow this circular. ಅದಕ್ಕೊಂದು ತಕ್ಷಣ circular ಇಲ್ಲ. They have to follow this circular.
ತಕ್ಷಣ ಅಂದ್ರೆ ಡೇಟ್ ಕೊಟ್ಟಂಗೆ. Date is this 10 minutes.
They have to follow this.
They have to follow.
There are circumstances why it is accepted. Situation becomes effective when it is accepted. Certain employees relieved of duties. There will have acceptance of the situation is affected only when the person relieved from service. There will not be no relieved or not.
Yes.
ಅದೊಂದು ಗೌಡ್ಸಲ್ಲಿ ಏನು ಕನ್ನಡ ಹೇಳ್ತಾರೆ ಇಂತ ಹೇಳ್ತಾರೆ ವೆಲ್ಕಮ್ the designation becomes effective in court. If it is relieved is duty. It is therefore necessary to see that handing over cash, recovery of goods to the employee, federal formalities, completed before the employee is relieved of duties. Then, otherwise, employee tenders resignation during the development of the resignation will be accepted from the date he remained unauthorizedly after the
Absenteeism.
Not in dispute that the respondent has rejected his salary, but accepting the resignation of the petitioner. That itself shows that the respondent has made upon lastly as expected. Whether they derive the class C of the circular or not, they are deducted 1 month salary. Well, they deducted 1 month salary, acted as
ನೀವು ಫೋರ್ತ್ ವಿತ್ ಅಂತ ಹೇಳಿದ್ರ then ಅಲ್ಲ ಅಂದ್ರೆ 1 month ಕಂಪ್ಲೈನ್ಸ್ ಆಗ್ಲಿಲ್ಲ. ನಿಮ್ಗೆ ಕೆಲಸ ಬ್ಯಾಡ್ ಅಂದ್ರೆ ಯಾಕೆ ವೇಟ್ ಮಾಡ್ಬೇಕು ಎಂಪ್ಲಾಯರ್ ಅಂತ. Why should an employer wait when ಓದಿ.
So that the respondent has made upon class C. Even a limit of class C and instructed above do not empower the respondent to deduct a salary.
Yes,
What are the guidelines? Starting we accept the notice of adjournment. If there are circumstances warranting such acceptance, the guidelines is the order. Acceptance of resignation. See page.
Nimrita,
Okay.
Annexure C page. Yes.
This is Jalaga Tomato. Now the Interim now Jalago is Rajaname. The Interim Jalaga.
Yes.
ಮುಂಚಿತವಾಗಿ ಮದುವೆ ಕೊಡದೇ ಇರುವಂತ ಒಂದು ತಿಂಗಳ ವೇತನವನ್ನು ಮುಂಚಿತವಾಗಿ ಕೊಡಲು ಅವರಿಂದ ಸಂಸ್ಕೃತಿ ಬರಬೇಕಾದ್ರೆ ಬಾಕಿ What are circumstances in which acceptance of visitation immediately that are not totally acceptance order? That is the law declared by this now. Continue. Not empower the respondent to get the salary. They did 1 month salary. They are not empowered to get 1 month salary.
Yes.
What are the guidelines provides for a competent authority may accept the notice of adjournment if there are circumstances warranting acceptance. Let me point out to not able to see in circumstances against the corporation to accept the no indication is found. No results are stated. in the next area, dated 8/9/94. Here also, see, does not display. For acceptance of resignation or action. So, in the absence of any circumstances warranting immediate acceptance of resignation, I do not see any reason to uphold the order of the respondent operation. The guidelines stated above clearly gives a procedure to be followed to accept the resignation, and the corporation has not followed the procedure. I am of the view that this is a to set aside. I am not able to accept the contention of the blended council operation. That a distinction can be made between last years and value. It may imply you last years. I think it together. It has to go. This is normally be accepted. It is only possible delay except in certain type of cases. Last year provides procedure to be followed in such a situation. If both last years here at result. I'm not seeing any. I'm not seeing.
I do not see how the corporation could accept.
Yeah, I'm not clear. After circumstances warranting such
ಅಲ್ಲ ಇದರಲ್ಲಿ ತಕ್ಷಣ ಅಂತ ಹೇಳಿದ್ರ ನೋಟಿಸ್ ಅವರು ರೆಸಿಗ್ನೇಷನ್ ನಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲ ಇದರಲ್ಲಿ ಎಲ್ಲಿ ಇದರಲ್ಲಿ ಎಲ್ಲಿ
even otherwise we have to follow separately and next day in the absence of any circumstances warranting that committed authority can accept the notice of adjournment if there are circumstances warranting that. That is so, I don't accept the situation. So, reason for accepting the situation is directed here. That is object. It is because of that I have to say object. I'm not able to accept the argument that the other council for calculator. The petitioner has said about the resignation that given a story that was valued wider and rejected. Other council for the petitioner has so that they can take it common is there. Considering the factor, the operation should have been before accepting it. If there are some compelling circumstances, warranting parents should have mitigated them in the order of acceptance. There will not there is absence in the order of acceptance.
What is the compelling circumstances? Where do you find this? Compelling circumstances, what are the compelling circumstances? Like what? Yes, yes.
The acquisitions would have indicated is there in the order of acceptance. Let's just see. Both are absent in this case.
Compelling circumstances ಮತ್ತೆ explanation. Yes.
As such, the order is not to subtraction. However, the same process is not to do that corporation, if you are invited to consider the letter of
ಇದರಲ್ಲಿ accept ಆಗೋಕ್ಕಿಂತ ಮೊದಲು ವಿಡ್ರಾ ಆಯ್ತಾ? ಹೌದು. So should be at a liberty. ನೋಡಿ. ಇದೆ ಹಾ. When did he give his representation here? In this,
The damage was upset and left his standing fine and he attempted to the conceiving fighter. Poor attempted to commit suicide, the prisoner submitted a letter of resignation on 7 The resignation seems to have accepted by the respondent on 8/9. However, the prisoner having been discharged to the hospital as a attended duty on 8/9 made also, but when the report for duty as written on 10/9 was not allowed to resume duty without that situation has been accepted. Subsequently, the prisoner might have made the same reason. But the prisoner has returned to resignation on 29 Especially for examination. But at this stage,
withdrawal 15/9 ಗೆ ಮಾಡಿದ್ರು after accepting. ಮುಂದೆ ಇದೆ ನೋಡಿ. Petitioner's wife has made a representation ಅಲ್ಲ ಮಾಡಿದ್ದಾರಲ್ಲ. They have made a representation seeking to withdraw the resignation. 23/10.
No reason is forthcoming ಅಂತ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದಾರಾ ಕೆಳಗಡೆ ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ
ಮುಂದೆ ಸಾಧ್ಯವಿದೆ ಎಂದು ತಿಳಿಸಿ ಸಲ್ಲಿಸಿರುವ ರಾಜೀನಾಮೆಯ ದಿನಾಂಕ 8/3/10 ಜಾರಿಗೆ ಬರುವಂತೆ ಅಂಗೀಕರಿಸಲಾಗಿದೆ. So this means your worship. So what is the compelling circumstances? How it was accepted ಅನ್ನೋದು 8/3/2009 what ಇವಾಗ ರಾಜೀನಾಮೆ ಇದೆಯಲ್ಲ that will be a part of this order now. So 8/3/10 ಜಾರಿಗೆ ಅಂಗೀಕರಿಸಲಾಗಿದೆ. That means your worship it is in continuation of 8/3/2010. This order has been passed.
Yes.
So therefore, your worship, though it is not reflected, your worship, all the facts in this have the very word used, your worship, 8/3/2010 anniversary. Reverse facts now is designation, the whole context has taken as it is. Full acceptance of the resignation. Then your worship, his question, your another question, your worship, he was not released. The moment he resignation submitted also from the next day, it was second bandila. Second bandila, then the question of I am not really on a question. He said, driver, your worship. The official charge of discharge model, discharge model, relieve model, this driver of the corporation. Your driver was relieved section, your worship, what is submitted. I laid up one judgment, your worship, I have submitted, your worship.
Yes. Para 10 and 13 both.
Para 10, 13 of these, para 10 years. The perusal of the relevant clause of official memorandum 11/19 disclosure. The resignation is required to be intimated by the disclosure intention to resign after office both either immediately or after future date. Here also worship, intention should be there when it is. In the later case, such future date should be prescribed. The resignation has to be clear and unconditional. The respondent did not specify any future date, but submitted his resignation writing in his resignation to resign clear and unconditional. Clause 4 contains the circumstances under which the resignation should be accepted. This is for the guidance of the official concern and does not create any right in the now your worship was laying upon circular.
Yes.
Any right in the employer concerned to resist acceptance of resignation. Clause 3 specifies that resignation becomes effective when it is accepted and government servant is relieved of his careful reading of this clause throws some light as to why the requirement of relieving a government servant has to be indicated in the office memorandum. The second sentence of the clause states that normal rule of the government servant can withdraw his letter of resignation before the acceptance by appointing authority. Next following sentence spells out that in case of resignation had been accepted by the appointing authority and the employee is to be relieved from the request for withdrawal of resignation is received from the employee, the normal rule should be to follow the request to withdraw the resignation. But even in such case, the request of withdrawal may be refused, but the ground for rejection should be recorded and implemented to the ground for concern. Then you must have a 12 In the listed case, the letter of acceptance clearly shows that unless the postponement service after his offer of resignation was not referred to any future date, and hence there is no requirement to relieve him of his duty. Even the peculiar type of case shows that respondent while on probation had already abandoned his service for almost 8 months and had not carried to report the government. So, relieving government, the question does not arise for this reason. The very letter he states that your lawsuit should be given with immediate effect. So that immediate effect your lawsuit will have an order referring to the letter dated 8/3/2000, saying that it's an immediate effect that you have to accept.
Speaker or how many years he worked in the institution, corporation after the order passed? And date of resignation was 2010. ಅವಾಗ ಎಷ್ಟು ಏಜ್ ಇತ್ತು 2010 ಅಲ್ಲಿ? All benefits received,
Salary ಮಾತ್ರ ನಾವು ಏನು ವರ್ಕ್ ಮಾಡಿದ್ರು ಸ್ಯಾಲರಿ ತಗೊಂಡು ಮಿನಿಮಮ್ ಸ್ಯಾಲರಿ they request for December for directed ಅಲ್ಲಿ ಅವರು ಮಾಡಿಸ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ ನೀವು ಅಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರಲ್ಲ ಈಗ 8 ವರ್ಷ. ಏನ್ ಓದ್ತಾ ಇದ್ರ ಪ್ಯಾರಾ 14?
Being a driver of the corporation, there is no formalities for relieving his service or taking charge from the applicable only in the category of government acceptance relief no separate order requires
ಅಲ್ಲ ಅದು ಅವ್ರದ್ದು ಕಂಟೆನ್ಷನ್. ವಿ ವಿಲ್ ಗೋ ಆನ್ ಲಾ. ಸರ್ಕ್ಯುಲರ್ ಕರೆಕ್ಟ್ ನಿಮ್ದು, ಬಟ್ in this in the peculiar facts ಹೆಂಗ್ ಕೊಡ್ತೀರಾ resignation? Please accept my resignation ಅಂತ ಹೇಳ್ತೀರಾ. In this you made a mention, you should give it an immediate effect, not giving a future date to it. ಅವ್ರದ್ದು ಅಲ್ಲ, they said that letter ಇದೆ. This is ಅಲ್ಲ, in light of the letter ಅಂತ ಹೇಳ್ತಾರೆ.
Have to accept resignation, warning, accepting the resignation within 1 month.
we would accept.
There is a lot of leverage on the Islam.
Hello, we are absolutely with you. But now in light of this special circumstances, where you said not giving nothing, if you would have said just take my resignation without saying that takshana togolo future date to ಹೇಳಿಲ್ಲ. ಅವ್ರಿಗೆ ಬೇಕೇ ಬೇಡ ಅಂತ see, when a employee does not want to work with any employer, you should never retain that employee. You should not even retain him for a day. ಅಲ್ಲ ಎಷ್ಟ್ ಸಲ ಇದು ಆಟನ ಒಂದ್ಸಲ ಬರ್ತಾನೆ. ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, otherwise law is against you. Now this court will pass an order, it could be against you. Mr. Bhandari, now that he has already attained superannuation, can you think of something of just settling the matter and keep it, give him some relief? Now that he has worked so many years, alva, now if you say something now, he will not get anything.
ಅವತ್ತೆ ಯಾವಾಗ್ಲೇ ವಜಾ ಮಾಡ್ತಿದ್ರು ಬೇಡ ಅಂತ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ನಾವು ಅನ್ಕೊಂಡಿದ್ದೀವಿ.
ಈಗ ವಜಾ ಮಾಡಿದ್ರೆ now your petition would go, the order of the order of the labor court has to be set aside. What happens is the date of resignation 2010 now.
ವರ್ಕ್ ಸಿಗ್ತಾ ಇದೆ ನಾವು ದೇಶಕ್ಕೆ
ಈಗ ವರ್ಕ್ ಮಾಡಿದ್ದೀರಾ ಇಷ್ಟು ದಿವಸ, what to do?
ಒಪ್ಕೊಳ್ಳೋದು ನಾವು ಯಾಕೆ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾವು ಅದನ್ನ ಒಪ್ಕೊಳ್ತಾ ಇಲ್ಲ.
ಏನಾರ ಮಾಡ್ತೀರಾ ನೋಡಿ ಇದರಲ್ಲಿ. ಒಂದ್ಸಲ ಮಾತು ಕೇಳಿ. ಅಲ್ಲ in this correct, but now ಇದರಲ್ಲಿ ಏನು ರೆಸಿಗ್ನೇಷನ್ ಇದು ಬೇರೆ, ಇದು ಬೇರೆ. That is why this court, that is why this, now that is why this court is asking the corporation advocate to see whether what can be done in this matter. Because you were working for so many years. Now if you set aside the order of the labor court, whatever benefit you would get, you would not be entitled. Though you must have worked, you have got salary, worked and got salary ashte. Alva?
Except the land, Dakshinadinda annadu.
That is important.
Follow the circle and
ಅಲ್ಲ ಮಿಸ್ಟರ್ ಶೇಖರ್ ಅವರೇ, ಒಂದ್ ಮಾತು ಹೇಳಿ, when the employee says ಬೇಡಪ್ಪ ನನಗೆ ಬೇಡ ಹೀಗೆ ರಿಲೀವ್ ಮಾಡಿ, why should the employer at least wait for some time? ಅಲ್ಲ, there is no procedure. ಅಲ್ಲ, when compelling circumstances. ಯಾರು ಹೇಳ್ತಾರೆ ಬುದ್ಧಿವಂತ ಇಲ್ಲ? Sometimes we have to keep a knot to this type of practices by the employees. Now, bare employees harassment anta ಹೇಳ್ತೀವಿ. What is the harassment of not to the employer only? ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದು, whether they can look into this and see what can be done. Mr. Bhandari ಅವರೇ, ತಗೊಳ್ಳಿ instructions ತಗೊಳ್ಳಿ. Otherwise, Mr. Shekhar, give him some benefit. We should give some benefit for only this court is thinking because he was reinstated. That's all. Otherwise, the granting of interim order and making him to be reinstated would not be any benefit to him. It's just an interim arrangement. If ಹೇಳಿ 40. ಏನಿದು? What is this? ಅದರ್ ಬೇರೆ ಅವ್ರದ್ದು, ಅದೇ ಬೇರೆ ಅವ್ರದ್ದು.
ಜಾರಿಗೆ ಬರುವಂತ ಆಗಿತ್ತು.
Again? Article, ಅದೇ article.
ಹೋಗಿ ಸ್ಪೀಕರ್ ಸಲ್ಲಿಸಿರುವ ಮನವಿಗಳನ್ನು ಕಾನೂನು ರೀತಿಯ ಅವಧಿಗಳಿಸಿ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ರಾಜೀನಾಮೆ ತೆಗೆದುಕೊಂಡರು. ಸುಮ್ಮನೆ ನೀಡಿ ಅವರನ್ನು ಹೋರಾಟದ ಸಿದ್ಧಾವಳಿಗಳಿಗೆ ದಿನಾಂಕ 29/9/94ರಿಂದ ಏರ್ಕಂಡಲ್ ಯೋಜನೆಯ ಮೇರೆಗೆ ಶ್ರೀಯುತರು ಉದ್ಯೋಗದಲ್ಲಿ ಹಾಜರಾಗಿರುವ ಅವಧಿ ವೇತನ ರಹಿತ ರಜೆ ಎಂದು ಪರಿಗಣಿಸಲಾಗಿದೆ. He made representation in the 1995 presentation ಕೊಟ್ಟಿರೋದು ಅವರು 51-10-94, 51-2-95, 53-95. was accepted on 21-10-94.
ಅದರಲ್ಲಿ ತಕ್ಷಣ ಅಂತ ಹೇಳಿದ್ರಾ? ಇಲ್ಲಲ್ಲ, ಅದರಲ್ಲಿ ತಕ್ಷಣ ಅಂತ ಹೇಳಿದ್ರಾ?
ಒಂದು ವರ್ಷದ ಮೇಲೆ ತಗೊಂಡಿದ್ದಂತೆ ವೆಜಿಟೇಬಲ್ ಒಂದು 8 ತಿಂಗಳ ಮೇಲೆ
ಇವನು ಒಂದ್ಸಲ ಕೊಟ್ಟ ರೆಸಿಗ್ನೇಷನ್ ಎಂಪ್ಲಾಯಿ.
ಅವ್ರು ಹೇಳೋದು cannot be removed at any point of time.
ನಾವು ಹೇಳ್ತೀವಿ.
ಅದಕ್ಕೆ ನಾನು ಇದು ಮಾಡಿದ್ದೇನೆ. ಯಾರೋ ನಾವು ರಿಮೂವ್ ಮಾಡಿದ್ದೇವೆ ಹೇಳ್ತಾರೆ. ಪರಿಗಣಿಸಿ ಪರಿಗಣಿಸಿ ಸಿಚುವೇಶನ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರು ತಗೋಬಹುದು ಅಂತ ಕಾನೂನಲ್ಲಿ ಅವಕಾಶ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಪಾಸ್ಪೋರ್ಟ್ ಎಂಪ್ಲಾಯ್ ನಾನು ಒಂದು 24 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದೀನಿ. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಾನು ಒಂದು ಹೋರಾಟದಲ್ಲೇ ಬಂದಿದ್ದೀನಿ. ನಾನು ವಿಡ್ರಾ ಮಾಡಲಿಲ್ಲ. ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ನಾನು ಒಂದು 6 ತಿಂಗಳು ವರ್ಷ ಬಿಟ್ಟು ಬಂದಿದ್ದೆ. ಬೆನಿಫಿಟ್ ವಿಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೆ. ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ immediately I invested representation. Suppose I am not granted any consequences of consequences. Consequences benefits is concerned, I have to do so.
Okay.
Straight away on this part.
Compelling circumstances for the employer to accept the resignation is that the employee did not want to work. He wanted to relieve himself immediately.
So that have not been forthcoming in the.
That is your representation, your resignation.
Not accepting, when they are accepting, they are applying the money for accepting. Before 1 month period, they have to state it in the accept the solicitation order. But not been forthcoming, so this is order.
Other contrary, other contrary, it one law is there. There is one another judgment of this court itself. It is 1995. Yes, Mr. Bandari, ಏನ್ ಮಾಡ್ತೀರಾ? Kindly look into this. ನೀವು ಇನ್ನೊಬ್ರಿಗೆ ಕೊಟ್ಟು ಇನ್ನೊಬ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ then they will parity ಕೇಳ್ತಾರೆ ಅವರು. Parity for ಇದರಲ್ಲಿ ನೆಗೆಟಿವ್ ಇಲ್ಲ. Now that he is retired, superannuated, you say that he is not entitled, goes back to 2010.
Without any complaint or bad remark.
After that work also he has been doing, after that resignation. Please. ಯಾವಾಗ? ನಾಳೆ ಹೇಳಿ, ಅಂದ್ರೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಗ್ಬಿಡತ್ತೆ. ಹೌದೌದು. Heard Bennett counsel on both sides in part to hear further this matter tomorrow. ನೀವು ಪಾಸಿಟಿವ್ ಆಗಿ ಹೇಳ್ಕೊಂಡ್ ಬನ್ನಿ ಮಿಸ್ಟರ್ ಭಂಡಾರಿ ಅವರು. ಶೇಖರ್ ಅವರ ಇದೇನು ನೋಡ್ತೀರಾ ಅನ್ಆಥರೈಸ್ ಆಬ್ಸೆಂಟ್ ಎಷ್ಟು ದಿವಸ ಎಷ್ಟು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಮೈನರ್ 11A ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಹೆಂಗ್ ಬರುತ್ತೆ ಮೈನರ್ ಎಷ್ಟು ದಿವಸ ಅಬ್ಸೆಂಟಿಸಮ್ 180 days ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ 2005 ನಾಳೆ tomorrow at the request of L. Shekhar. Yes, Mr. Prabhakar.
The respondent, my lord.
Yes, yes. You're for the workmen.
Yes, my lord. Leela Krishnan has given
Ah.
this file.
The letter from Mr. Somshekhar has filed additional statement of objection, which I did not. All rejoinder is required. I only request 3 days accomplishment. I to clarify the issue raised after that additional issue. Clarify that. Sorry, madam.
Additional documents,
Additional statement of objection document. I expect I did not notice. He told me also. Some rejoinder is required. I have to get affidavit from Coimbatore. 3 days protest after.
Petitioner counsel submits that the petitioner needs to file rejoinder to the additional statement of objections filed by respondent number 2 and seeks for 3 days time. Release this matter on Monday. Mr. Somshekhar on Monday.
Yes, madam. Yes, madam. Yes, madam. Yes, madam.
He is insisting for that. And usually Mr. C.K. Subramanian does not take time, Mr. Somshekhar.
I know, my lord, but only thing is in this, all of them are in higher cadre. Their pay scale is fixed in the P1 scale. That is my request. They are not clarifying that.
Whatever
If
on
my
merit.
judges not clarify, that is the only thing.
Yes, on merits, I don't think C.K. Subramania would at any time take time. He would always argue the matter.
Yes.
He is ready.
Yes.
All the cases. So the rejoinder to the additional statement of objection is very much necessary.
Monday.
Yes, madam.
Same. ಮೇಲೇನೆ ಬರ್ತದೆ. And why you don't appear in the matters which are listed in also in the further hearing? ಅಲ್ಲ further hearing ನಲ್ಲಿ ಯಾಕೆ appear ಆಗ್ಲಿಲ್ಲ ನೀವು? You appear for Nagbhushan, right?
Tomorrow, dear.
So and so counsel seeks time. List this matter on Monday. Yes, Mr. Joseph. Sir. Ready na? Monday. You're ready? He's ready. Allowed madli alla. You're also not feeling well andre ಏನು ಈಗ not well ಅಂತ ಆಯ್ತಾ? What is the issue regarding this tender? What is the tender?
Combination.
You're the order of termination. He was a permanent employee.
There are two issues arose before the learned court. But one is whether whether he would fall under the definition of 2S because he was involved in a managerial position. That was the question, main question, as a threshold question, my lord, the consideration, my lord.
According to you, he doesn't fall under the definition of 2 years and he is not a workman
He is
and
not wrong.
the dispute before the labor court was not maintained.
Not made. Please.
The labor court answers section 2 yes in favor of the workman.
In favor of the work. Holds that he was a workman at the time. Whereas I have document, my lord, which would show that he was in a managerial position.
And those documents were produced before the labor court.
What I have seen.
Was your objection to the effect that he is not a workman? And regarding the documents, you did not produce it before the labor court. Least on Monday. Tuesday,
So,
at request of respondent counsel. Yes.
Posting on authority order. Okay, then talking about Sanjeev.
Yes, Mr. Sanjeev. What was the misconduct? You are the petitioner. Workman is served and he is unrepresented. Most of the matters are by Sanjeev or Renuka madam. Is it not? Absenteeism here. He was absent for only 15 days or something like that. 15 days. Tomorrow at request of the petitioner. This file. Ten one CD. All after 2 weeks.
And Preeti?
Connected matters? There are another connected matters other than these petitions? Yes. Which matter? Who has to argue this matter now? First. Krishna. What to do if consuls are not there? Who has been engaged? Least on 13. Ah,
17th September.
Yes. You want the court to adjourn at the convenience of your senior when he is free, he will come to the court and argue the matter. Is it so? Then we will dismiss your petition for non-prosecution. So can you make a submission that your senior is not free on so and so date and he will not attend the court on so and so date? Can that be a submission, madam? Ask him to be present, and on that day, if he is not present, we will impose cost on you. Yes.
7, punishment and duty.
Yes, L. Shaker seeks time on the ground that the petition papers are not served. Yes, next week. But other. Yes, Mr. Prashant.
48, Prashant speaking.
Crossover.
49, Sachin PS.
Okay. 25. 35, huh? That is not similar matter, right? That is not similar. Similar, huh? Yes, list this matter on 9.
Adjourn 51, H. Shaker.
Yes, Mr. Shaker. The claim statement is rejected, huh? What was the misconduct? Dereliction of duty, na? What was his duty and what did he do? Twenty-four. Yes. 24 page na annexure B tane. Shivraj Chalaka.
ದಾಖಲಾತಿಗಳಾದ ಕೇಸ್ ಪ್ರಕರಣದ ಹಾಜರಾತಿ ಪಟ್ಟಿ ಕೇಂದ್ರ ಕಚೇರಿ ಆದೇಶ ಪ್ರಕಟಕ್ಕೆ ನೀಡಿದ ಕೇಂದ್ರ ಕಚೇರಿ ಆಡಳಿತ ಪಿಎ ಬಿಲ್ಲುಗಳ ಪ್ರತಿಗಳನ್ನು ನೀಡಿತ್ತು ಗೊತ್ತಿರಾದ ವಿಧಿಧಿಕಾರಿಗಳ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ಹಾಗೂ ಪತ್ರಿಕೆಗಳಲ್ಲಿ ಕೃಷಿ ಪ್ರಕಟಗೊಳ್ಳುವ ಮೂಲಕ ದಕ್ಷ ಶಿಸ್ತು ಮತ್ತು ವೃತ್ತ ನಿಯಮಾವಳಿ ಭಾಗ 2ರ ನಿಯಮ 10 ನೀಡಿರುತ್ತೇವೆ. ಇದರಿಂದಾಗಿ ನೀವು
That was ಇದು ಪ್ರೆಸ್ ನಲ್ಲಿ ಬಂದಿತ್ತಾ ಮತ್ತೆ ನೀವು ಏನು ಎಲ್ಲ ಮಾಡಿ ಅವ್ರನ್ನು
ಏನ್ ನೋವಾಗಿದ್ದೀನಿ ಹೇಳ್ಕೊಂಡಿದ್ದೀನಿ ಅಲ್ಲ ಏನ್ ಅನ್ಯಾಯ ಆಗಿತ್ತು ಅದನ್ನ
ಅದು ನೀವು ಅವ್ರಿಗೆ ಹೇಳ್ಬೋದಲ್ಲ ಏನ್ ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂತ ನಿಮ್ಮಲ್ಲಿ ಡಿಫೆಮೇಶನ್ ಹಾಕೊಂಡಿಲ್ಲ ಒಳ್ಳೇದು
ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಚಾರ್ಜ್ ನೀವು ಚಾಲಕ ಬೋಧಕರಾದ ನೀವು
ಚಾಲಕ ಬೋಧರಾದ ನೀವು ಕೇಂದ್ರ ಕಚೇರಿ
ನೀವು ಕೇಂದ್ರ ಕಚೇರಿ ಆದೇಶದಂತೆ ಕಡಿಮೆ ಕೆಎಂಪಿ ಚಾಲಕರಿಗೆ ಪ್ರತಿದಿನ 4 ಕೆಎಂಪಿ ಸುರಕ್ಷಾ ಚಾಲಕರಿಗೆ ತರಬೇತಿ ನೀಡಬೇಕಾಗಿತ್ತು. ಈ ತರಬೇತಿ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಯಾವುದೇ ಆದೇಶ ಕೊಡದೆ 29 ಜನ ಮಾತ್ರ ತರಬೇತಿ ನೀಡುವ ಮೂಲಕ ಕರ್ತವ್ಯವನ್ನು ನಿರ್ದೇಶಿಸುತ್ತದೆ. ಪಿಎಂಇನ್ನು ತಡವಾಗಿ ಸಲ್ಲಿಸಿದ್ದು ಈ ಆರೋಪವನ್ನು ಸಹ ಸಂಸ್ಥೆ ಮೇಲೆ ಹಾಕಿರುತ್ತೇವೆ.
ಅಂದ್ರೆ ನೀವು ಇವೆಲ್ಲ ಆರ್ಟಿಕಲ್ಸ್ ಕೊಡೋದಾಯ್ತು ಮತ್ತೆ ಏನ್ರ ಟ್ರೈನಿಂಗ್ ಕೊಡ್ಬೇಕಂದ್ರೆ ನಾನ್ ಯಾಕೆ ಮಾಡ್ಲಿ ಅಂತ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಯು ಆರ್ ಅಪ್ಸೆಟ್ ವಿತ್ ವಾಟ್ ದಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಡಿಡ್ ಬಟ್ ಯು ಶುಡ್ ಹ್ಯಾವ್ Who's, it is in his handwriting, huh? Whose handwriting is this? So neat he has written, with not even alphabet here and there. ಇಷ್ಟು ನೀಟ್ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಇದ್ದವರು ಮನ್ಸು ಇಷ್ಟ ಹೆಂಗ ಚಂಚಲ್ ಇರತ್ತೆ. ಹೌ ದ ಮೈಂಡ್ ಫ್ಲಕ್ಚುಯೇಟ್ಸ್. ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಸ್ಪೀಕ್ಸ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಇದು ಉಲ್ಟಾ ಆಗ್ಬೇಕು. ಅದು ಬೇರೆ ಇದೆ. ಅದೇ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್, ಯೂಶಲಿ ದಿ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ಸ್ ದಿ ಮೈಂಡ್ ಸೆಟ್ ಆಫ್ ಅ ಪರ್ಟಿಕ್ಯುಲರ್ ಪರ್ಸನ್. ಇದು ನೋಡಿದ್ರೆ ಇವಂದಲ್ಲ, ಅದು ಬೇರೆ ಬೇರೆ ಇದೆ. ಅವಂದಲ್ಲ. ಹಾ, ಈ ಪ್ರಕರಣದಲ್ಲಿ
ಗಮನಕ್ಕೆ ತರದೆ ಅನಧಿಕೃತ ಸುದ್ದಿ ಮಾಧ್ಯಮ ಹಾಗೂ ಪತ್ರಿಕೆಗಳಿಗೆ ತಿಳಿಸಿದಾಗ ನೀಡಿ ಅಧಿಕಾರಿಗಳ ಬಗ್ಗೆ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ನಾವು ಭದ್ರತಾಂತೆ ನೀಡುವ ಬಗ್ಗೆ ಆರೋಪ ಮಾಡಿದ್ದು ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಘಟನಾತ್ಮಕ ಸಹಿ ಇದ್ದು ಹಾಗೂ DPO ಅವರ ಸಹಿ ಇರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು ನಾನು ಒಮ್ಮೆ ಕಚೇರಿಗೆ ನೀಡಿದ ನಂತರ ಅದು ನನ್ನ ಮತ್ತೆ ಬರುವ ಪ್ರಮೇಯವೇ ಇರುವುದಿಲ್ಲ. ನಾನು ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇದೆ. ಆದ್ದರಿಂದ ಸದರಿ ದಾಖಲೆಯನ್ನು ನಾನೇ ಪತ್ರಿಕೆ ನೀಡುತ್ತೇನೆ ಎಂಬುದು ಬರೆ ಮಾಡಿರುವ ಸುಳ್ಳು ಆರೋಪವಾಗಿರುತ್ತದೆ. ದಾಖಲೆಯನ್ನು ಪತ್ರಿಕೆಯವರು ಅಧಿಕಾರಿಗಳಿಂದ ಪಡೆದಿರುವುದವಾಗಿ ಇರುವುದರಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಅದು ನನ್ನ ಮೇಲೆ ಮಾಡಿರುವ ಈ ಆರೋಪವನ್ನು ನಾನು ಒಪ್ಪುವುದಿಲ್ಲ. ನಾನು ಯಾವುದೇ ಇಲಾಖೆ ದಾಖಲೆಯಾಗಿ ಪತ್ರಿಕೆಯನ್ನು ನೀಡದೇ ಇದ್ದು ನಾನು ನನಗೆ ನೀಡಿದಂತಹ ಕಚೇರಿ ಆದಂತಹ ಪ್ರತಿಯನ್ನು ಮಾತ್ರವೇ ನನ್ನ ಸಂಬಂಧಿಕರ ಹಸ್ತ ನೀಡುತ್ತೇನೆ. ಅದು ನನಗೆ ಬಂದಂತಹ ಪ್ರತಿಯಾಗಿದ್ದು ಈಗ ಸಂಬಂಧಿಕರು ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ನೀಡಿದ್ದು ಅದು ತಪ್ಪೇನೂ ಇರುವುದಿಲ್ಲ. ಸದರಿ ಹೇಳಿಕೆ ನಾನೇ ನೀಡಿರುತ್ತೇನೆ ಎಂಬುದರ ಬಗ್ಗೆ ಆಯುಕ್ತ ಸಾಕ್ಷಿದಾರರು ಯಾವುದೇ ಸಾಕ್ಷಿಯನ್ನು ಪತ್ರಿಕೆ ಸಂಪಾದಕರಿಂದಾಗಲಿ ಪತ್ರಿಕಾ ಪ್ರತಿನಿಧಿಯಿಂದಾಗಲಿ ಪಡೆದಿರುವುದಕ್ಕೆ ಸಾಕ್ಷಿಯಾಗಿರುತ್ತದೆ. ಇದಕ್ಕೆ ತೊಂದರೆ ಮಾಡಲಿದ್ದು ಅವರೇ ಪತ್ರಿಕೆಗಳಿಗೆ ವಿವರಗಳನ್ನು ನೀಡಬಹುದಾಗಿರುತ್ತದೆ.
ಇದೊಂದು ಬೇರೆ ಅಲ್ಲ, ಇದೊಂದು ಬೇರೆ ಅವರೇ ಹಾಕಿದ್ದಾರೆ ಅಂತ.
27/3/2000 ಕೇವಲ 20 ಜನ ಚಾಲಕರ ತರಬೇತಿ ನನ್ನಿಂದ ತಪ್ಪಾಗಿರುವುದಿಲ್ಲ. ಏಕೆಂದರೆ ನಾನು ಚಾಲಕ ಬೋಧಕನಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುವ ಯಾವ ಚಾಲಕರಿಗೆ ತರಬೇತಿ ನೀಡಬೇಕು ಅವರನ್ನು ಕರ್ತವ್ಯದಿಂದ ಮುಕ್ತಿಗೊಳಿಸಿ ಅದನ್ನು ತರಬೇತಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುವ ಉದ್ದೇಶದಲ್ಲಿ ಮಾತ್ರ ಅದನ್ನು ತರಬೇತಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಬೇಕೇ ಹೊರತು ಅಂತವನ್ನು ತರಬೇತಿಗೆ ಕಳಿಸಿಕೊಡಿ ಎಂದು ಆದೇಶಿಸುವ ಅಧಿಕಾರ ನನಗೆ ಇರುವುದಿಲ್ಲ. ಯಾರು ತರಬೇತಿಗೆ ಹೋಗ್ಬೇಕು ಅವ್ರನ್ನ ರಿವ್ಯೂ ಮಾಡಿಬಿಟ್ಟು ಅಲ್ಲಿ ಹೋಗುವ ತರಬೇತಿ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಅವ್ರು ನನ್ನ ಕಡೆ ಕಳಿಸ್ಬೇಕು.
ಕೊಟ್ಟಿಲ್ಲ
ಇಲ್ಲ ಅಂತ ಯಾರು ಕಳಿಸಿದ್ರೆ ತರಬೇತಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಆದ ಕಾರಣ ಸರಿ ಸಮಯದಲ್ಲಿ ಘಟಕ ವ್ಯವಸ್ಥಾಪಕರು ಎಷ್ಟು ಜನಕ್ಕೆ ತರಬೇತಿ ನಿಯೋಜಿಸುತ್ತಾರೋ ಅವರಿಗೆ ತರಬೇತಿ ನೀಡಿರುತ್ತೇನೆ. ನಾನು PA ಬಿಲ್ ಅನ್ನು ತಡವಾಗಿ ನೀಡುವುದಾಗಿ ನಾನು 7-9-2014 PA ಬಿಲ್ ಅನ್ನು ನೀಡಿದ್ದು ಅದನ್ನು ಘಟಕ ವ್ಯವಸ್ಥೆ ಕಚೇರಿಯಿಂದ ವಿಭಾಗೀಯ ತಡವಾಗಿರುತ್ತದೆ ಹೊರತು ಅನ್ಯತ್ರ ತಡವಾಗಿರುವುದಿಲ್ಲ. PA ಬಿಲ್ ಕೊಟ್ಟು ಅದನ್ನು ಡೆಲಿಗೇಷನ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಸರಿಯಾಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದನ್ನ ಡಿಪೋ ಮ್ಯಾನೇಜರ್ ತಾವು ಗಮನಿಸಬಹುದು. ತಾವು ತರಬೇತಿ ನೀಡಲು ಸಕ್ರಿಯ ಕಳಿಸಿರುವುದು ವರ್ಗಾವಣೆಯನ್ನು ಈ ಬಗ್ಗೆ ಸಂಬಂಧಿತ ಪತ್ರಿಕೆ ನೀಡುತ್ತಾರೆ. ನಾನು ಯಾವುದೇ ಪತ್ರಿಕೆಗೆ ಹೇಳಿಕೆ ನೀಡುವುದಿಲ್ಲ. ನಾನು ಪತ್ರಿಕೆಗೆ ಹೇಳಿಕೆ ನೀಡುವ ಬಗ್ಗೆ ಯಾವುದೇ ಸಾಕ್ಷಿ ಇರುವುದಿಲ್ಲ. ಇದು ಸುಳ್ಳು ಆರೋಪವಾಗುತ್ತದೆ. ಮುಖ್ಯವಾಗಿ KMPL ಇನ್ಸ್ಪೆಕ್ಟರ್ ಕೆಲಸದಲ್ಲಿ ದಿನನಿತ್ಯ ಕೆಲಸ ಮಾಡಿರುವ ಬಗ್ಗೆ ಮಾಹಿತಿಯನ್ನು ಡೈಲಿ ಬರೆದಿದ್ದೇನೆ ಮತ್ತು ಅರುಣ ಮತ್ತು ಚಲವೇಗೌಡ ಇಬ್ಬರು ಯಾವುದೇ ಕೊಲೆ ಮಾಡುತ್ತಿದ್ದರು ಇದನ್ನೆಲ್ಲ ಬರೆದಿದ್ದೇನೆ. ಆಮೇಲೆ GM ರವರು ಎಲ್ಲಾ ಕೆಲಸಗಳಿಗೂ ಉಪಯೋಗಿಸುತ್ತಿದ್ದರು. ಅಂದ್ರೆ ಗಾಳಿ ಬೇರೆಯಿಂದ ಕವಿದ ಮೋಟಾರ್ ಮತ್ತು ಜೀಪ್ಗೆ ಹೊರಗೆ ಹೋಗುವಾಗ ಟ್ರಕ್ಗೆ DWS ಹಲವಾರು ಕೆಲಸಗಳಿಗೆ ಕಳುಹಿಸುತ್ತಿದ್ದರು. ಮನೆಯಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ತೆಗೆದುಕೊಂಡ್ರೆ ನಾನು CKM ಘಟಕದಲ್ಲಿ ಚಾಲಕ ಬೋಧಕ ನಾನು ಹಿಂದೆ ಎಷ್ಟು KMPL ಇತ್ತು ಅದರ ಮೇಲೆ ಎಷ್ಟು ಇತ್ತು 2 ಚೆಕ್ ಮಾಡಬೇಕೆಂದು ಕೇಳುತ್ತಿರುತ್ತೇನೆ. ಆಗುವಂತೆ ಎಷ್ಟಿತ್ತು ಇಂಪ್ರೂವ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ. KMPL ನೇಮಕವಾಗಿದ್ದಾಗ ನನ್ನನ್ನು ಬೋಧಕ ಹುದ್ದೆಯಲ್ಲಿ ಇರಿಸಿ ಚಾಲಕನಾಗಿ ಮಾರ್ಗಗಳಿಗೆ ಕಳಿಸಬಹುದಾಗಿತ್ತು. ಅದನ್ನು ಬಿಟ್ಟು ಸಕಲೇಶ್ವರ ಘಟಕಕ್ಕೆ ಮೂವ್ಮೆಂಟ್ ಆರ್ಡರ್ ಹಾಕಿ ಕಳುಹಿಸಿ ದಿನಗಳ ನಂತರ ವರ್ಗಾವಣೆ ಮಾಡಿದ್ದೇನೆ ಎಂದು ಕಳಿಸಿರುತ್ತಾರೆ. ನಮ್ಮ ಮಕ್ಕಳ ವಿದ್ಯಾಭ್ಯಾಸ
ಇದು ಇವ್ರದ್ದು ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೋರ್ಟ್ ಆಫೀಸ್ ರೆಕಾರ್ಡ್ಸ್. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್? ಏನ್ ಪನಿಷ್ಮೆಂಟ್ ಈಗ?
also not a speaking order. They are given it's not findings and the main house acted by me.
ನ್ಯೂಸ್ ಪೇಪರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ವಾ? ಮಾಡಿದ್ದಾರೆ. And there was a mention of his name. So and so says so. For the court officer. Court officer. Tirukala. Oh, his grievance. ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? ಎಷ್ಟು ಪೇಪರ್ ನಲ್ಲಿ? ಸೇಮ್ ಡೇಟಾ? ಬೇರೆ ಬೇರೆ ಡೇಟ್ ಕಂಟಿನ್ಯೂಸ್. Which are those marked as exhibit? Exhibit M14. He approached the appellate authority as well. The detail nalli illi. ಎಲ್ಲ ಅದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. He has admitted in his evidence. And there is an
ಏನ್ ಬಂದಿದ್ದಾರೆ ಸ್ವಲ್ಪ ಓದ್ತಿದ್ದಾರೆ. ಹಿರಿಯ ಶೃಂಗೇರಿ ಕ್ಷೇತ್ರದ ಶಾರದಾ
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು? ಅದು ನೆಕ್ಸ್ಟ್ 2-3 ಇದೆ ಇಲ್ಲಿ. KSRTC ಅಲ್ಲಿ
ಇನ್ಸ್ಪೆಕ್ಟರ್ಗೆ ಆತ್ಮಹತ್ಯೆ ಯೋಚನೆ, ಅಧಿಕಾರಿಗಳ ಕಿರುಕುಳ ಆರೋಪ. ಇಲ್ಲಿನ ರಾಜ್ಯ ರಸ್ತೆ ಸಾರಿಗೆ ಸಂಸ್ಥೆ ಘಟಕ ವ್ಯವಸ್ಥಾಪಕರು ಮತ್ತು ಅಕೌಂಟ್ ಸೂಪರ್ವೈಸರ್ ಅವರಿಂದ ತೀವ್ರ ಕಿರುಕುಳವಾಗುತ್ತದೆ ಎಂದು ಆರೋಪಿಸಿರುವ ಡೀಸೆಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಶಿವರಾಜ್.
ಮತ್ತೆ ಅವ್ರ ಹೆಸರೇ ಇದೆ.
ಬೆಳಗಾವಿ ಸಂಬಂಧಿಸಿದವರು ತಪ್ಪಿಸಬೇಕು. ಇದರಿಂದ ಯಾವ ರೀತಿಯ ತೊಂದರೆ ಆದರೂ ಎಂತರಗಳ ಕಾಲ ಎಂದು ಪ್ರತಿಜ್ಞಾಪತ್ರ ನೀಡಿದ್ದಾರೆ. ನಾನು 11 ವರ್ಷಗಳ ಕಾಲ ಕೆಎಸ್ಆರ್ಟಿಸಿ ಚಾಲಕರಾಗಿ ಯಾವುದೇ ಲೋಪವಿಲ್ಲದೆ ದುಡಿದು ಸುಮಾರು 1 ವರ್ಷ ಚಿಕ್ಕಮಗಳೂರು ಘಟಕದಲ್ಲಿ ಡೀಸೆಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ. Details given to the newspaper have not been produced here. That the persons who publishes the newspaper have not been examined in the exam. Only on the basis of the paper certificate they say.
ಅವ್ರು ನಿಮ್ ಹೆಸರೇ ಇದೆಯಲ್ಲ, did you did?
Newspaper print ಮಾಡೋದು ನಾನು ಕೊಟ್ಟಿದ್ದು ಅಂತೇಳಿ ಕೊಟ್ಟಿರೋ ಬರ್ಕೊಟ್ಟಿರೋ ಒಂದು ಲೆಟರ್ ಬೇಕಲ್ವ, ಲೆಟರ್ ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ವ. Important has not been examined. Newspaper has not been examined. ನನ್ನ ಬಂದಿದೆ ಆರ್ಟಿಕಲ್ ನಾಳೆ ಕೊಟ್ಟಂತ ಬಂದಿದೆ. When I am disputing, the burden is on the management to charge.
ಅಲ್ಲ, ನಿಮ್ಮ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಹೆಸರು ಮೆನ್ಷನ್ ಮಾಡಿ ಆರ್ಟಿಕಲ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ವಾಟ್ ವುಡ್ ಬಿ ಯುವರ್ ಗ್ರೀವಿಯನ್ಸ್? ನಿಮ್ ಗ್ರೀವಿಯನ್ಸ್ ಇಲ್ವಾ? ಅಲ್ಲ, when you have given, forget. See, there is a paper article. There is a paper article. If you are disputing that you are not giving, then you should have given complaint against that newspaper media. When you put complaint. When you want the court to believe that you have not done it, because burden is on you. You have to prove that you had not issued this articles in the newspaper when your name depicts there. And you have come to the court saying that you have not given any of this precedent. ಅಷ್ಟೇ ಅಲ್ವಾ ಇವ್ರೆ?
The main ground adjudication is
Order of punishment, domestic inquiry is conducted fair and proper.
Punishment possible responding in the typically include or not speaking order. Serious engagement was made against the prisoner. Prisoner submitted detailed explanation and also then detailed cross-examination. Even before the tribunal, the prisoner examined himself in detail. Respondent cross-examined the prisoner as well. Nothing has been initiated to the motive of the prisoner. This is very of the cross-examination of workman in the employment. Position of arrangement is test. Rapid examination. The earthquake moved their admin. They did 2-3 call.
To 2012. Whose evidence you want to place reliance?
Yeah. Assistant, usual office. This is tempo disclosure.
M4, M4 dated,
Four ಆದ್ಮೇಲೆ ಅವರು ಪ್ರೆಸೆಂಟಿಂಗ್ ಆಫೀಸರ್ ಅವರು ನೆಕ್ಸ್ಟ್ ಪೇಜ್
M1 ಅಷ್ಟೇ ಇರೋದು.
ಫೋರ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಡಿಪೋಸಿಷನ್ ಆಫ್
18-2,
ಅದ 2009
only one person is examined as MW1.
ವರದಿಗಾರ ಹೇಳಿಕೆ 2009 ವಿಚಾರಣಾ ದಿನಾಂಕ ಅದರಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಎಸ್ ಎನ್ ಅರುಣ ಹಿರಿಯ ಘಟಕ ವ್ಯವಸ್ಥಾಪಕರು ಸೋಲ್ಸ್
ಇಲ್ಲಿ ಇದು ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ಮುಂದೆ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಬೇರೆ
Receive where it is.
Scheduled actually as 7 documents. After that, reviewing the amount to M7. Next page is class examination. On 2/3/2012. So, examination chief ಆಗಿರೋದು 28/2/2009. Class examination ಆಗಿರೋದು 2/3/2012. Because 3 years.
Yes, you cross examine the witness ಅಲ್ವಾ? ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಾ? ಮತ್ತೆ ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಕ್ರಾಸ್ ಮಾಡಿದ್ದೀರಾ? ಹಂಗಿದ್ಯಾ? Where is that reason?
ನಾನು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತೂ ಇಲ್ಲ.
ಬಂದಿಲ್ಲ ಕ್ಲಾಸ್ ಮಾಡಿರ್ತೀನಿ. ಆಕ್ಷನ್ ಮಾಡೋದು ಗೊತ್ತಾಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಆಫೀಸಿಗೆ ಅಲ್ಲಿ ಎಲ್ಪಾಗಿ ಬೇರೆ ಪ್ರಾಪರ್ ಆಗಿದ್ದೀನಿ.
Just look into the order sheet. Tribunal. Look into the order sheet of the disciplinary authority. It must be there in the records. You have to say that this order of the disciplinary authority. ಹೇಳಿ.
ನೋಡೋದಾದ್ರೆ
ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಇಲ್ಲ.
Disclosed. 28/2/2009. ರವಿನಾರಾಯಣ ಆಪಾದಿತ ಮತ್ತು ಆಡಳಿತಪರ ವರದಿಗಾರರು ಹಾಜರಿದ್ದರು. ಆಡಳಿತಪರ ವರದಿಗಾರರು ತಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿದರು. ಆಡಳಿತಪರ ವರದಿಗಾರರನ್ನು ಪಾಟಿ ಸವಾಲಿಗೆ ಒಳಪಡಿಸಲು ಅವಕಾಶ ನೀಡಿ ದಿನಾಂಕ 7/3/9 ವಿಚಾರಣೆಯನ್ನು ನಿಗದಿಪಡಿಸಿದೆ. ಅದೇ ದಿನಾಂಕದಂದು ಆಪಾದಿತರು ಮತ್ತು ಆಡಳಿತಪರ ವರದಿಗಾರರು ಹಾಜರಿರುವುದಿಲ್ಲ. total absent on 7/3/2009. Again, my lord, on 23/4/2009, both are absent. Again, on 23/7/2009, my lord, both are absent.
Both are absent.
on 28/2009, September present. ವಿಚಾರಣೆಗೆ ಹಾಜರಿದ್ದು ಅಡ್ಡಪರ ವರದಿಗಾರರು ಹಾಜರಿರುವುದಿಲ್ಲ. ಅರ್ಜೆಂಟ್ 49 ನಲ್ಲಿ ಎಂಕ್ವೈರಿ ಆಫೀಸರ್ ವಾಸ್ ಚೇಂಜ್. ಪ್ರಕರಣ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 7/12 ವಿಭಾಗೀಯ ಕಚೇರಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಲಾಸ್ಟ್ ನೋ ಎಂಕ್ವೈರಿ ವಾಸ್ ಹೆಲ್ಡ್ ಫ್ರಮ್ 28/2009 to 7/2/2012. ಎಂಕ್ವೈರಿ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ ಅವರು. Inquiry officer was appointed. No inquiry officer was appointed in 2010. 26/10/2010. The inquiry officer fixed the date of hearing on 7/2/2012. Then our problem is ಆಮೇಲೆ 7/2/2012 I am not appear. Then my lord on 4/2/2012 ನಾನು ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ಆಳ್ದ ಪ್ರಸಾದ್ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿದ್ದು ಅವತ್ತು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 2/3/11 ವಿಚಾರಣೆಗೆ ಅಪಾಯಿಂಟೆಡ್ ಜವಾಬ್ದಾರಿ ಮತ್ತು ಅವತ್ತು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿತ್ತು. ಅವತ್ತು ಏನಾಯ್ತು ಅಂತ ಸ್ವಲ್ಪ ನೋಡೋಣ. ನೀವು ಸಲ್ಲಿಸಿರುವ ವರದಿಯು ನಿಮ್ಮದೇ ವರದಿಯು ಅಥವಾ ಲೆಕ್ಕಪತ್ರ ಮೇಲ್ವಿಚಾರಕರ ವರದಿ ಮೇಲೆ ಸಲ್ಲಿಸಿರುವುದು ಖುದ್ದಾಗಿ ನೋಡಿ ಸಲ್ಲಿಸುತ್ತೇನೆ. ಅರ್ಥ ಇಲ್ಲ, ನನಗೂ ಅರ್ಥ ಇಲ್ಲ, ಅರ್ಥ ಇದೆ.
ಖುದ್ದಾಗಿ ಯಾವ ತರ
ನೀವು ಸಲ್ಲಿಸಿದ ವರದಿ ನಿಮ್ಮದೇ ವರದಿಯೋ ಅಥವಾ ಲೆಕ್ಕಪತ್ರ ಮೇಲ್ವಿಚಾರಕರ ವರದಿ ಮೇಲೆ ಸಲ್ಲಿಸಿದ್ದೀರೋ, ನೀವೇನು ಪರ್ಸನಲ್ ಆಗಿ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರೋ ಅಥವಾ ಬೇಸ್ಡ್ ಆನ್ ದಿ ರಿಪೋರ್ಟ್ ಆಫ್ ಅಕೌಂಟ್ ಸೂಪರ್ವೈಸರ್ ತರ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಕೇಳಿದ್ರೆ ಖುದ್ದಾಗಿ ನೋಡಿ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ.
ಅವರೇ ನೋಡ್ಕೊಂಡು
ಸಲ್ಲಿಸಿದ್ದೀನಿ. ಖುದ್ದಾಗಿ ಅಂದರೆ ಯಾವ ದಿನಾಂಕ ಸಮಯವೆಂದು ಪರಿಶೀಲಿಸುತ್ತೇನೆ. ವರದಿಯನ್ನು ತಯಾರಿಸಿದ ದಿನಾಂಕ ಮತ್ತು ಪತ್ರ ಸಂಖ್ಯೆಯನ್ನು ನಮೂದಿಸಲಾಗಿದೆ. ಚಾಲಕರನ್ನು ಚಾಲಕ ಬೋಧಕರಾಗಿ ನೇಮಿಸಿರುವುದು ಸಂಸ್ಥೆಯ ನಿಯಮಗಳಿಗೆ ಅನ್ವಯವೇ ಅಲ್ಲವೇ? ಹೌದು. ಅವರಿಗೆ ಏನೇನು ಕರ್ತವ್ಯ ವಹಿಸಿರುವಿಲ್ಲ. ಕೇಂದ್ರ ಕಚೇರಿಯಿಂದ ಸುತ್ತೋಲೆಯನ್ನು ಹೊರಡಿಸಿ
ಅಲ್ಲ, ಇದು ಅವ್ರದ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ನಿಮ್ದು ಏನ್ ಎವಿಡೆನ್ಸ್? ನಿಮ್ದೇ ಇರ್ಬೇಕು. ಇದ್ರಲ್ಲಿ ಏನ್ ಸಿಗುದಿದೆ ನಿಮ್ಗೆ?
ಮಾಡಿದ್ದೀನಿ ನಾನು, ಅವ್ರು ಹೇಳಿದ್ದೀನಿ. ಫೆಬ್ರವರಿ 14 ಇದೇ ವರದಿ ಚಾಲಕ ಬೋಧಕರಿಗೆ ತಮ್ಮ ಕರ್ತವ್ಯ ಲೋಪದ ಕುರಿತು ಉಚಿತವಾಗಿ ತಿಳಿಸಿತ್ತು. ತಮ್ಮ ಕರ್ತವ್ಯ
ಇದು ಆರ್ಟಿಕಲ್ ನೀವ್ ಕೊಟ್ಟಿಲ್ಲ, ನೀವು ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್. ವೇರ್ ಇಸ್ ದಟ್ ಟು ದಟ್ ಇಫೆಕ್ಟ್?
ಬಿಡುಗಡೆ ಮಾಡಿ ನಿಯಮಗಳು ಉಲ್ಲಂಘನೆ ಮಾಡಿರ್ತಾರೆ. ಚಾಲಕ ಬೋಧಕ ತಮ್ಮ ಕರ್ತವ್ಯ ಲೋಪದ ಕುರಿತು ದಾಖಲೆ
ಅದಕ್ಕೆ ನಿಮ್ದು ಎವಿಡೆನ್ಸ್ ಗೆ ಬಂದ್ಬಿಡಿ.
ಆಪಾದನೆ ಪತ್ರಿಕೆಯನ್ನು ಅಕಸ್ಮಾತ್
ಅಲ್ಲ, ನೀವು ನಾಟ್ ಅ ಸ್ಪೀಕಿಂಗ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳ್ತೀರಾ, ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್. ವಾಟ್ ಇಸ್ ದ ಗ್ರೌಂಡ್ ಫಾರ್ ಯು ಟು ಸೇ ದಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಅ ಸ್ಪೀಕಿಂಗ್ ಆರ್ಡರ್? ಎಲ್ಲಿ Annexure B. ವಿಚಾರಣೆ ಸಾರಾಂಶ ಅದೇ ಬಿ.
ಅಪರಿಚಿತ ಚಾಲಕ ಇವರು ಚಿಕ್ಕಮಗಳೂರು ಘಟಕದಲ್ಲಿ ಚಾಲಕ ಬೋಧಕರ ಕರ್ತವ್ಯವಿರುವಾಗ ಮೇಲಧಿಕಾರ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಅನಧಿಕೃತವಾಗಿ ಪತ್ನಿಗೆ ಸಂಸ್ಥೆ ದಾಖಲಾತಿ ಪತ್ರಗಳನ್ನು ನೀಡಿ ಸಂಸ್ಥೆಯ ಅಧಿಕಾರಿಗಳ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ಹಾಗೂ ಪ್ರಚೋದನಕಾರಿ ನೀಡಿ ಸಂಸ್ಥೆಯ ಶಿಸ್ತುಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿರುವ ಚಾಲಕ ಬೋಧಕರಾಗಿದ್ದುಕೊಂಡು KLT ಮತ್ತು ಸುರಕ್ಷತೆಯಲ್ಲಿ ಆಸಕ್ತಿ ತೋರಲು ಕಡಿಮೆ ಚಾಲಕರಿಗೆ ತರಬೇತಿ ನೀಡಿರುವ ಮತ್ತು ಸಂಸ್ಥೆ ಬಗ್ಗೆ ತಪ್ಪಿತಸ್ಥರು ನೀಡಿ ಸಂಸ್ಥೆ ಬಗ್ಗೆ ಮಾಡಿರುವುದು ಹಿರಿಯ ಘಟಕ ವ್ಯವಸ್ಥಾಪಕರು ಚಿಕ್ಕಮಗಳೂರು ಅಧ್ಯಯನ ಸಲ್ಲಿಸುತ್ತಾರೆ. ವರದಿಯ ಆಧಾರದ ಮೇಲೆ ಹಿರಿಯ ನೌಕರಿಗೆ ಆರೋಪಣಾ ಪತ್ರ ಜಾರಿಗೊಳಿಸಿ ಅಪಾಯದ ಆರೋಪಣಾ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಪ್ರಕರಣ ಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಿರುವಾಗ ಅಪಾಯದ ಆರೋಪವನ್ನು ಸಲ್ಲಿಸುವುದು ಅವಕಾಶದಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ವಹಿಸಲಾಗಿತ್ತು. ವಿಚಾರಣೆಯನ್ನು ಸಂಸ್ಥೆಯ ನಿಯಮಾವಳಿಗೆ ಅಪಾಯದಲ್ಲಿ ನ್ಯಾಯದಾರರ ಅವಕಾಶದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆಸಿ ಅಪಾಯದಲ್ಲಿ ಆರೋಪ ಪತ್ರ ಆರೋಪಗಳ ಮೂಲಕ ಅಧಿಕೃತ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸುತ್ತಾರೆ. ಅಪಾಯದ ಮೇಲೆ ಆರೋಪವನ್ನು ಪೂರ್ಣ ಅನ್ಯಾಯದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದಾರೆ. ಹಲವಾರು ವಿಚಾರಣೆ ಮಾಡಿದ ಅಪಾಯಕರು ಇತರ ತಮ್ಮ ಆರೋಪ ನಡೆಸುತ್ತಿಲ್ಲ. ನಾವು ವಿಚಾರಣೆಯನ್ನು ಒಪ್ಪಿದ್ದು ಅಪರಾಧಿಗಳಾದವರಲ್ಲಿ ಅಪಾಯಕರಿಗೆ ಅನುಕೂಲ ಅಪರಾಧಿಗಳಾದವರ ಆರೋಪವನ್ನು discussion with regard to contingent legal measures after examination. In the findings of the inquiry, perversity in the findings pointed out in the display to the setup, not stated anything in the final order. Not a taking order here. First term, the pressure. And thing is here. That's in my mind. Mentioned that the clear denial on the part of the petition regarding litigation everything. Madam is only responding to examining the better of the regarding who given information to the author. Only admission made by the petitioner that pardon was handed over to his relative. The relative may inform the same to the proprietor of the newspaper.
So he does not dispute that there is an order given to his relative. There is something given.
ನಮ್ಗೇನು ಆರ್ಡರ್ ಅದನ್ನು ಡಿನೈ ಮಾಡ್ಬೋದಾಗಿತ್ತು ಮಾಡಿಲ್ಲ ನಾನು
ಇಷ್ಟು ಡಿನೈ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಇಷ್ಟೇ ಇಂಪೋಸಿಷನ್ ಆಫ್ ಪನಿಷ್ಮೆಂಟ್.
is something that is told of the award. Rather, deciding officer stated that it is the duty of the employee to keep the secrets of the corporation. No doubt to that the petitioner is not responsible for publishing the same in Pejawari, Madhyama, and other newspapers. If we will do that, but a newspaper settings have been settled. It cannot be treated that information is given by the presumption cannot be wrong to punish the frequent employee. The reason signed by the present presiding officer in Procedural award is considered.
This is your main ground.
That's my got it.
ನೋಡಿ ನೀವು reply ನಲ್ಲಿ ಒಂದು ಸ್ಟ್ಯಾಂಡ್ ತಗೋತೀರಾ. Reply ನಲ್ಲಿ you say relatives must have been given ಅಂತ. ಅಲ್ಲ ಕರೆ ಇಲ್ಲಿ no in your ಇದರಲ್ಲಿ claim ಅಲ್ಲಿ ಇಲ್ಲ ಹಂಗೆ. Claim is silent regarding that aspect. You say you have totally denied it. Taken a totally different version. ಇಲ್ಲ ನೋಡಿ ನಿಮ್ claim ಕೊಡು. ಇದು ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿನಾರೇ ಹೇಳ್ಬೇಕು. ಇಲ್ಲಿ ಕ್ಲೇಮ್ ವಾಪಸ್ ಕೊಟ್ರ ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ ಇಲ್ಲ. Kindly look into his evidence also. Evidence. MWW1. ಕೊಡಿ ಅವ್ರಿಗೆ. We have not even stated a single thing about that aspect. ಅದೇ ನೀವು claim is silent about it. ನೀವು ನಿಮ್ದು ರಿಲೇಟಿವ್ ಬಗ್ಗೆ ಏನು ಹೇಳಲ್ಲ. Where is your evidence? Evidence is the replication of your claim statement. Yes. ನೀವು ಫಸ್ಟ್ ಗ್ರೌಂಡ್ ಏನ್ ಇರ್ತೀರಲ್ಲ ಅದೇ ಕರೆಕ್ಟ್. ಎಸ್ ಅಷ್ಟೇನಾ? Assailing the legality and correctness of the order dated 27th April 2019 in reference number 165 of 2019 on the file of the Industrial Tribunal at Mysore, wherein referred to as Tribunal for short, whereby the reference made by the government and the claim statement was rejected by the tribunal. Articles of charges were issued to the workman stating that the workman, without permission or sanction from the corporation, gave articles or documents and information to the press. And further that while he was working as a trainer, he was to give training to 4 to 6 daily work drivers as per the rules. And without showing any interest in his duty, he has given training to only 29 drivers from 5/3/2007 to 27/3/2007. And he has submitted TA bill in time. And he has not submitted TA bill in time. Further, that the salary is being paid in time and the workman has made allegation against the corporation. Next, the inquiry was conducted. Inquiry officer was appointed. An inquiry of show cause notice was issued to the workman for giving explanation of giving information to the newspaper and for dereliction of duty. The workman replied to the show cause notice stating that the information replied to the notices. The disciplinary authority, while considering while accepting the inquiry report, the inquiry officer submitted his report holding that the charges leveled against the workman is proved. The disciplinary authority accepted the inquiry report and the material placed before it, passed an order of punishment holding that the order of punishment imposing reduction of 2 increments with cumulative effect. The workman, the workman raised dispute and the government referred the dispute to the industrial tribunal under section 10, clause 1E of the Industrial Dispute Act 1947 ID Act was shot. The workman filed claim statement stating that the corporation, without any valid reasons, during the time of his service as a trainer, as a driver, and during the said time, the management has issued articles of charges on 28/1/2008 that he misused the powers and also made publication pertaining to the Sakleshpura KSRTC depot documents and made of the news item in the daily newspaper between 5/3/2007 to 27/3/2007. Newspaper and also between 5/3/2007 to 27/2007. He has given only training to 29 workers. The workman approached the labor court contending that the reply submitted by the workman against the allegations of charges were not considered, and that the alleged paper publications regarding the matters pertaining to the corporation were only best known to the competent authority of the corporation better than the workman. The workman stated that there is no nexus between the workman and the allegation and the charges, including the paper publication. And sought for setting aside the imposition of punishment of withholding 2 increments with cumulative effect. The corporation filed counter inter alia contending that inter alia disputing the claim statement and contending that the workman, without permission or sanction from the corporation has given articles, documents and information to the press. And further, the articles of charges issued were on basis of his misconduct. And that the inquiry officer, by holding proper inquiry, has held that the charges leveled against the workman is proved. And the disciplinary authority have decided has passed the punishment order considering the inquiry report and the material placed, and that the same would not warrant any interference. The tribunal on the issue whether the domestic inquiry conducted was fair and proper, held that the domestic inquiry is held as fair and proper. And thereafter, the parties let in evidence on merits. The workman examined himself as WW1, and the management witness was examined as MW1. The workman marked documents. No documents were marked on behalf of the workman. Management marked documents at exhibit M1 to M90. The tribunal, by the impugned order, rejected the reference and held that imposition of punishment by the disciplinary authority was just and proper, and there is no perversity or illegality in the order passed by the disciplinary. When it comes reiterating the petition, reiterating the grounds urged in the petition would mainly contain that one, the impugned order of punishment passed by the respondent is not a speaking order, and when a serious allegation was made against the petitioner, the petitioner has submitted detailed explanation and also cross-examined the witness of the management before the disciplinary authority. When the petitioner disputed the charges referred to in the article of charges and submitted a detailed explanation both to the article of charges and the inquiry findings, the disciplinary authority ought to have given a reasoned order about while considering the evidence of WW1, and after analyzing the evidence left before the disciplinary authority and considering the same, the disciplinary authority ought to have passed the order of punishment. That the disciplinary authority even did not discuss the evidence available on record and summarily imposed the punishment, and that the punishment order is not a speaking order. Next. That when the petitioner workman has denied regarding the allegation leveled against him, the burden is on the management to prove the charge by examining the proprietor of the newspaper regarding who has given information to the proprietor, and only admission made by the petitioner that the order was handed over to his relative and his relative may inform the same to the proprietor of the newspaper, and he has not given any information to publish the same in the newspaper. The contrary to the statement made by the petitioner, the tribunal rejected the reference that the award passed at an exchange is not sustainable as the tribunal has not appreciated the evidence available on record in accordance with law. For contra, the learned counsel appearing for the corporation justifies the order passed by the disciplinary authority and the order passed by the tribunal, and it contained that the newspaper extract clearly at Exhibit M14 clearly indicates the name of the workman, and on whose pretext the articles or documents were published in the newspaper. The it is from the counsel for the respondent would contend that the reply submitted by the workman at the first instance clearly indicated that he had submitted the order to his relative, and his relative might have informed to the newspaper, which aspect is totally absent in the claim statement of the workman and workman, that the tribunal, considering the nature of misconduct and the inquiry conducted and the disciplinary authority imposing of punishment on the workman, has rightly held that there is no perversity and illegality in the order passed by the disciplinary authority, and not rightly interfered by the tribunal, which warrants no interference by this court. Having heard the learned counsel for the parties, the point that arises for consideration is whether the impugned order passed by the industrial tribunal warrants any interference in the present facts and circumstances of this case. The articles of charges were issued by the workman for the misconduct, which reads as under page number, lecture B, page number 24. The articles of charges issued was for publication of articles, documents, and information to the press, and also that he, while he was a trainer, he has not given training to the drivers from 5/3/2007 to 27/3/2007, and only 29 drivers were trained, and there was a dereliction of duty. The labor court held that the domestic inquiry conducted by the corporation is fair and proper. On merits, the WW1 workman let in evidence, and he admitted that, and he stated that he was working as a trainer to the driver at Chikmagalur division. The evidence of WW1 indicates the cross-examination of WW1 indicates that he has admitted that a permission has to be taken from the superiors while making any statement to publisher. However, the workman has denied about the press report being given, and also about the confidential matters regarding the DA bills and order of central office. The workman has examined, the management examined from S. Basvaraj, the administrative officer, as the MW1. The inquiry officer as MW1. The inquiry officer stood the test of the cross-examination and stated as to the issuance of charges and the report submitted. The presenting officer, the inquiry officer, submitted that there is a mention regarding the issuance of notice to the witness. And about the inquiry, correct, the postponement of,
Collecting of the inquiry, procedure to be adopted in the inquiry.
correct, ಅದೇ main ಅಲ್ವಾ ಈಗ?
Adopting prayer draft.
ಅಲ್ಲ, now you say that it was not a speaking order ಅಲ್ವಾ? By the disciplinary authority. The inquiry officer stood the test of the test of the cross-examination and stated that the inquiry was conducted fair and proper. The labor court held that the domestic inquiry conducted by the inquiry officer was fair and proper. The question that calls for consideration is whether the learned counsel for the petitioner has stated that the main ground urged by the petitioner is that the order passed by the disciplinary authority at annexure D is not a speaking order. Comparison of the order at annexure D would indicate that the petitioner, that the disciplinary authority, while imposing the punishment of reduction of 2 increment, has given his reasons at para number 2, which reads as under, page number 34, Kannada number. Whether did you raise that ground before the tribunal? No. From the perusal of the claim statement, it evidences that the workman has not raised a ground about the order passed by the disciplinary authority not being a speaking order. And in the absence of the same did not call for consideration before the tribunal. The tribunal held the tribunal, while considering the material placed, more particularly Exhibit M14, which indicates the name of the petitioner being stated in the newspaper for having published the article, and the charge, then considering the same, the inquiry officer held that the charges leveled against the workman was true. The disciplinary authority, while considering the entire evidence placed before it and the publications, arrived at a conclusion that the charges leveled against the workman have been proved and imposed the punishment of reduction of 2 increments with cumulative weight. The industrial tribunal held that there is no perversity in the inquiry report of the inquiry officer. And inquiry officer. The other contention of the petitioner is that the burden is on the respondent to prove the charges by examining the proprietor of the newspaper. When the fact remains that the charges were issued against the workman had to discharge the burden that he had not misconducted himself on the articles of charges framed against him. The reply submitted by the workman is to the effect that the order was handed over to his relative, and this relative might have informed the proprietor of the newspaper. The relevant portion of the reply submitted by the workman reads as under Annexure C, page number 29. Extract. Yes. The said contention. The contention, the labor court, the tribunal, by considering the entire materials placed before it and considering the inquiry report and the order of the disciplinary authority, arrived at a conclusion that the disciplinary authority has rightly passed the impugned order and the same does not warrant any interference. The point for consideration framed by this court is answered against the petitioner for the foregoing reasons. And this court passed the following order. The writ petition is dismissed. The impugned order passed by the industrial tribunal stands confirmed. Because give this copy of that paper publication. This one.
Become round, will be ready at any point of time.
This will answer that also. Yes.
Even if I am not taken such contention before the labor.
At least you should make an averment in your petition that the
It will be taken at any point of time. It is allowed. It is assigned.
Learned counsel for the petitioner submits that in spite of not taking a specific ground of not being a speaking order of the disciplinary authority, the same can be urged before this court. The perusal of the impugned order the perusal of the order of the disciplinary authority would indicate that the order passed by the disciplinary authority is a speaking order, which is considered by the tribunal. Next. Yes. Yes. Monday. 10 na? ಏನಾಯ್ತು? 9. 10th. 10th. Yes, Mr. Yes, Shekhar. Nagraj. ಇದು minor punishment, dismissal. What was the misconduct? ಎಷ್ಟರಿಂದ ಎಷ್ಟು ದಿವಸ? From when to when he was up?
That is 2013, that is up to the date of issuance of article of that. It is the contention taken by the workman.
What is that ground for your absence?
Question the findings accorded by the the principal district judge on issue number 1. Regarding fairness of domestic inquiry is concerned. While issuing notice some court
Point for consideration. In support of unauthorized petitioner has not furnished any documentary information material in the present. Therefore, petitioner's counsel is permitted to produce the necessary documents if any. The first order. When it counsel for the petition is directed. Prima facie, the perusal of the impugned award dated 11/12/2018. It is evident that there is no discussion in respect of exhibit R14, medical certificate and medical prescription. Exhibit R15 and R16. R15, ಅಲ್ಲ ನಿಮ್ದು ಪಿಟಿಷನ್ ಅಲ್ವಾ ನಿಮ್ದು ನಾಳೆ ಟುಮಾರೋ ಟುಮಾರೋ ಇದು ಟುಮಾರೋ ನಾಳೆ yes why 2 petitions?
The short version of that, was with ex parte, my lord, it was not present. The option of ex parte was never present. Evidence was conducted, denied back, no opportunity was given to process down the evidence. So I argued,
He was represented by where is the inquiry finding?
not present, the site is also not there on the site. At this stage, the CSE started consulting at the ego as right and not such activities not getting paid. At the ego and let's get you to the objection.
What officer? Where is that?
Is now whatever the ego wants, have to trust that this is clearly expired. I stand on this, the feelings that are present.
And who has signed this management represent?
I didn't have an issue, I mean, notice me that you have to face expired.
No, but then management representative and then there is no signature of yours, is your contention.
The issue that you are saying that, I'm not even after that case expired. Even a letter to the MR or the EO, saying that you wanted to engage with an employee, record to particular.
Where is that? Where is that?
Let us take a record of damage to the copy. I requested to copy to engage I'm not even aware that says that I think expired. Even then, no notice is issued to me, or am I made aware that I think this expired. Evidence is comments of the man.
When was the order placing you ex parte? 15/3/2013.
evidence of commencement.
The first notice.
That is the certificate of debate of the certificate and unplaced ex parte. And evidence has not commenced at this stage. Then, my lord, evidence commences behind my back. I'm not present, I'm not well at this ex parte. I did various letters. Then, my lord, they examine two witnesses. And I don't get any opportunity to talk with them and report this down. What is the page 64 finding me?
It says that the CSE are present on 15/3/2023.
Yes, no, my lord, that's the chance that I shouted so and so and I walked away and that's what he is expired. My stances I was never present. At the very least, when there's a conflicting stance, the notice has to be issued to the
The CSE confirmed that he has received the copy of the inquiry of the proceedings dated 16/2/2013. Correct. Post sittings you are present. So you were aware. Then you suddenly go out and you expect the inquiry officer to issue one more notice to you. See, once the notice has been served upon you, you have to be present on all the dates. You, Ah.
I received the inquiry report, my lord. And these are the
Page 80. Yes. Hmm.
Till then, he recognizes he was informed around 15 and the grade. Then, follow from the bottom. ಆದರೆ 15/3/2013 ರಂದು ಯಾವುದೇ ವಿಚಾರಣೆ ನಡೆದಿಲ್ಲ.
How does he say so? There is an order sheet regarding that effect. See, he says no vicharane nadadilla. He doesn't say he is not present. What he says, no inquiry was held on. But then there are inquiry proceedings which has been held on 5/15/2013. Is it not? Is it not? Yeah. But his submission is, his reply is that on 15/3/2013, there is no proceedings at all held. He was, that cannot be. Now he knows about all the earlier proceedings. And he was given the date on 15/3/2000. He knows that 15/3 also.
He doesn't have the inquiry officer like that. So he gives letters to buyers and
Yes, yes.
So he gives those letters, madam, that is substantially short examination. He doesn't have the inquiry officer letter, so he sent it to the magistrate. Management has returned it, my lord, in the post. Saying the note that it's returned in the post, my lord. Which means, my lord, even during the pregnancy has repeatedly, he has not been given the inquiry officer.
Yes, yes.
He gives an representation. If I may read, my lord. ಯಾವುದು ವಿಚಾರಣೆ ನಡೆದಿಲ್ಲ ಯಾವ ಮಾಹಿತಿಯನ್ನು ಗೊತ್ತಿರಲಿಲ್ಲ ಆದರೂ ನಾವು ತನ್ನ ಮಾಹಿತಿಗೆ ಪತ್ರ ಬರೆದು ನಂತರ ಯಾವುದೇ ವಿಚಾರಣೆ ನಡೆಸುವುದಿಲ್ಲವೆಂದು ಅದರಿಂದ ಮುಂದಿನ ವಿಚಾರಣಾ ದಿನಾಂಕವನ್ನು ತಿಳಿಸಬೇಕೆಂದು ಕೋರಿ ಕಂಪನಿಯು ವಿಳಾಸಕ್ಕೆ ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ತಮ್ಮ ಯಾವುದೇ ವಿಳಾಸವನ್ನು ಕೊಡದೇ ಇರುವುದರಿಂದ ಅದನ್ನು ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಮೂಲಕ ಕಂಡುಹಿಡಿದಿದೆ. ನನ್ನ ಈ ಪತ್ರವನ್ನು ತೆಗೆದುಕೊಳ್ಳದೆ ನನ್ನನ್ನು ವಾಪಸ್ ಕಳುಹಿಸಲಾಗಿದೆ. ನನ್ನ ಪತ್ರವನ್ನು ದುರುದ್ದೇಶವಿಲ್ಲದೆ ಆಗಿನ ಮಂಡಳಿ ಯಾಗಲಿ ಅಥವಾ ವಿಚಾರಣಾಧಿಕಾರಿ ಆಗಲಿ ವಿಚಾರಣಾಧಿಕಾರಿಗೆ ಕಳುಹಿಸುವ ಮೊದಲು ವಿಚಾರಣೆಯಲ್ಲಿ ಪಟ್ಟಣಾಧಿಕಾರಿಯಾದ ನಮ್ಮ HR ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರ್ಗೆ ಪತ್ರವನ್ನು ಕೊಡಲು ಹೋಗಿದ್ದೆ. ಸರಣಿ ಪತ್ರವನ್ನು ನೀಡಿದ್ದೆ. ನೋಡಿದೆ ಅವನು ನೀವು ಈ ಪತ್ರವು ವಿಚಾರಣಾಧಿಕಾರಿಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಆಗ ನಾನು ಆದರೆ ವಿಚಾರವಾದಿ ವಿಳಾಸವನ್ನು ನೋಡಿ ಅವರಿಗೆ ಅಂಚೆ ಮೂಲಕ
ಯಾಕೆ ಅವ್ರ ವಿಳಾಸ ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ? There is an office premises where this enquiry is being held. Yes, yes. Yes. You continue this. Yes, continue. Yes. Continue reading this.
ವಿಳಾಸ ಕೊಡಿ ಅವರಿಗೆ ಅಂಚೆ ಮೂಲಕ ಈ ಪತ್ರವನ್ನು ಕಳುಹಿಸುತ್ತೇನೆ ಎಂದು ಕೇಳಿಕೊಂಡಾಗ ಅವರು ವಿಚಾರಣಾಧಿಕಾರಿಯನ್ನು ವಿಳಾಸವನ್ನು ಕೊಡಲಿಲ್ಲ. ಆಗ ನಾನು ಬೇರೆ ದಾರಿ ಇಲ್ಲದೆ ಸರಣಿ ಪತ್ರವನ್ನು ರಚಿಸಿದ ಕಂಪನಿಯ ವಿಳಾಸಕ್ಕೆ ವಿಚಾರಣಾಧಿಕಾರಿಯ ಬರೆದು ಕಳುಹಿಸಿದ್ದೆ. ಹೀಗಾಗಿ ಹೇಳಿದಂತೆ ಸರಣಿ ಪತ್ರವನ್ನು ತೆಗೆದುಕೊಳ್ಳುವುದರಿಂದ ಆ ಪತ್ರವನ್ನು ನನಗೆ ವಾಪಸ್ಸು ಬಂದದ್ದು. ಅದು ನಾನು ಈ ಪತ್ರವನ್ನು ದಿನಾಂಕ 3/7/2013 ಮತ್ತೆ ಕಳುಹಿಸಿದ್ದೆ. ಆ ಪತ್ರವನ್ನು ತೆಗೆದುಕೊಳ್ಳುವುದರಿಂದ ಅದು ಸಹ ನನಗೆ ವಾಪಸ್ಸು ಬಂದಿತ್ತು.
Yes. Yes, we continue tomorrow. Heard the petitioner in part. Place the matter for further hearing. Yes.
Or reinstatement and 3 lakh awardable. So on 23/9/2019, I prepared this repetition report. David was David was there. So the interim order due to some official reason, the interim order could not get it.
Could not be?
On 15/10/2019, he gave a letter to the labor commissioner that I am not implementing the order. 15/10/2011, 19. 28/11/2019, Labor Commission issued me a notice to implement the order. Otherwise, action will be taken in Schedule 5 of the Industrial Regulation. Now, on 12/12/2019, interim order was passed. And at that point of time, respondent was very much, the advocate was very much present. Is that only award in so far attracts 3 lakh was paid. Directly please schedule. That came before the court on 12/2/19. He did not complain about I am not reinstating. On 7/2/20, it came before the court also. On 2/3/23, it came. And 31/24, it came before you are not equally wrong. On 28/2/24, this day after is still you know. On 8/4/2024, three advocate filed wakalat law. On 24/2024, application of 17B was filed. So, the number sufficient there was a reinstatement order, and in the before tribunal also, I stated that I have no objection for not refusing the employment to be.
See, after an order is passed by this court, what is the procedure to be followed? What is the procedure? You go and report now.
I will report now. Now, since 2019, petition is pending.
Correct. Now you go and report.
But the mandatory requirement is that when the inspection is pending against an order of.
Correct. There is an order of reinstatement. You were aware about that order. Did you go and approach the this petitioner for reinstatement?
He has gone.
Where is that? To indicate that he has gone, what is that document? To go now and report. See, the 17B wages is without doing any work. Without doing any work. Correct, that is statutory, but when there is a provision, when they are asking you to rejoin, come for reinstatement, you don't want to work. And then
They
you,
have never asked. us to
then
do
let,
that. They made a false submission on the last, that they called me to work. Now they are telling there is no such document.
That I clarified your doubt.
oh, Mr. Consul, that day, even the other side consul was here. Now you cannot say that you had not made that submission. You said that you have issued notice to them. There was no matter on 5/8. Allah, Mr. Mr. Venkatesh, will you hear this court or only you will keep on arguing? Will you only keep arguing or will you listen to this court? Tell me, Andhra, what does it mean? See, the matter was listed on 5/8. It was directed to be listed on 6/8. On 6/8, the matter was, this court held that the petitioner submits that in spite the notice issued to the respondent, directing him to join the petitioner company, the respondent has not come forward. You said they have not joined. Then learned counsel for the respondent submits that the petitioner has not reinstated the workman as per the order dated so and so. And as such, I number 1 of 2024 is filed by the respondent for direction for settling the wages. At this stage, learned counsel for the petitioner seeks time to produce the material documents to indicate that they have directed the respondent to join the services of the petitioner company. This is the order of this court. Now there is no, you have not filed this application for recalling. You are not recalling.
I filed application. I filed this application on that control. He was advocate was present on that day.
What is this? Are we sitting in a cross-examination of an advocate here? Not very fair enough, Mr. Venkatesh. Mr. Venkatesh, not very fair on your part to make this. Like, if this was not your submission, how could be a recording of this by this court? Yes, Mr. Consul, this is not very, your colleague was present before the, then don't tell your colleague to be present before the court. And if on her submission, we have noted this. Whoever was present for the petitioner. We are not going to take her cross-examination here. Now there is a. What is this, Mr. Venkatesh? With so much of standing in this bar, do you make such a submission to the court? Do you make such submission to the court?
That what I'm trying to say,
Yes, we are not going to entertain such type of submission. Citation is one thing different. You are making an allegation to the court. You are making an allegation to the court. Are you sure about what you are making first? Are you sure about what you are making?
The submissions are wrong.
Of course, your submissions are wrong. We said that the petitioner is present. We did not take her name. I think now that causes a problem. Now we have to be very strict on saying as to who is the counsel appearing. Not very fair, Mr. Counsel. Yes, Mr. Govindraj, what happened on that day? What happened on that day? It was made, right? And on the submission of the petitioner, we have recorded this. Yes.
Then your lordship on the next day directed them to produce document. When I disputed their submission, your lordship directed them to produce material.
Yes. Now they cannot.
They are telling you it's a wrong submission.
Yes.
Sorry.
We will take it seriously, Mr. Go. Mr. Counsel, You know the repercussions of making such a submission. Let us not involve into it. Allah, let us not involve into it.
Not the second year. Second year ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವ್ರು ಹೇಳ್ತಾರೆ ನಾವು ಕೇಳಿ ಹೇಳ್ಬೇಕು ವೇಟ್ ಅಂತ ಹೇಳ್ತಾರೆ ಇವ್ರು ಹೇಳ್ತಾರೆ ಸೊ ಇವ್ರ ಮೇಲೆ ಹೇಳ್ತಾರೆ ಇವ್ರು ಹೇಳ್ತಾರೆ can I make it?
You have to produce documents if you have issued notice. Yes, learned counsel for the petitioner submits that the petitioner has no documents or materials to indicate that they had directed the respondent to join the services of the petitioner company. Pursuant petitioner to join the services of the petitioner company. I-1 of 2024 is filed for direction. Direction. If you are not taking him for reinstatement, you pay the 17B wages.
The interim order itself says.
Is filed by the respondent, directing the petitioner management to pay wages to the respondent as per section 17B of the Industrial Dispute Act 1947. It is stated in the application that the respondent, that this court passed an interim order on 12/12/2019, staying the award subject to reinstatement, and the respondent has not been reinstated so far. It is submitted that the respondent is not working after his illegal termination from his services, and he is neither gainfully employed anywhere, and that he is suffering from hardship due to the illegal termination and consequential loss of earning. It is stated that the petitioner management has not taken back the respondent to work, though there is a conditional interim order passed by this court on 12/12/2019. Per contra, the learned counsel, application heard ಅಂತ ಹಾಕೊಳ್ಳಿ. Learned counsel for the respondent workman, reiterating the contents stated in the application, would submit that the petitioner management has not taken the workman by way of reinstatement pursuant to the order dated 12/12/2019. And the petitioner management be directed to pay wages to the respondent as per section 17B of the Industrial Dispute Act, as the respondent is not gainfully employed anywhere. Full stop. Per contra, the learned counsel appearing for the petitioner, submits that the order dated 12/12/2019 was stayed by this court, that the impugned order of the labor court was stayed by this court subject to reinstatement and in the presence of the presence of the caveator. It is the submission of the petitioner that the respondent has not reported to duty in spite an order of reinstatement by this court on 12/12/2019, and the petitioner is not, and the respondent is not entitled for 17B wages. Full stop. The fact remains here that pursuant to the order passed by this court on 12/12/2019, where the impugned award was stayed subject to reinstatement, the respondent has not been reinstated by the petitioner management. In the said circumstances, the petitioner management is directed to pay the 17B wages in accordance with law from 12/12/2019 till today on current wages. The respondent workman to report to duty on or before date ಕೊಡಿ. ಅಲ್ಲ ನೀವು ಈಗ ತಗೊಳ್ಳಿ, ಅಲ್ಲಿಂದ ಅಲ್ಲಿ ತನ ವೇಜಸ್ ಕೊಡಿ, ಈಗ reinstatement ಮಾಡಿ. Mr. Council, we have already passed an order. Date, 1 week.
9th September.
9th September. And the petitioner management to reinstate the workman from 9th September. Failing to reinstate the workman, the petitioner management to continue to pay 17B wages. ಹೇಗೆ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಬರ್ರಿ ಅಂತ ಹೇಳಿದ್ವಿ ಅಲ್ವಾ? ಅಲ್ಲ, now that is coming, you take him. Now he is coming, take him. There is no provision for contempt. ಆಯ್ತು ಮಾಡಿ. You file contempt also. ಆಯ್ತು, next matter. Yes. Okay, tomorrow for further hearing. Yes. 46. When did we list it? 17, 19 ಅವಾಗ ಬರುತ್ತೆ. Thursday we take RSAs. 17. So now what has been directed? 50%, huh? You said, we said we will, yes, where is that Keshava? Keshava is a party in person, no? Party. So 10 lakhs we have to say, yeah? Back wages as a compensation. ಅಷ್ಟೇ ಬರುತ್ತಾ 50% back wages? Calculation. Salary is? That is from 1 August 1996. Six lakh 16, round about to 10 lakh ಅಂತ ಮಾಡೋಣ. ಅಷ್ಟೇ ಬರುತ್ತಲ್ಲ ಅವ್ರದ್ದು? It comes ಅಲ್ಲಂದ್ರೂ yes, 10 lakhs. If you take the whole salary of him. 90. We will give reasons to follow. Writ petition is allowed in part. The note ಮಾಡ್ಕೊಳ್ಳಿ. The petitioner counsel submits that the factory is closed. 16/4/2006. You have produced along with the? Where is that? As per Annexure D in document. Okay. Under 25O, na? Okay. Petitioner counsel submits the factory has been closed in light of the application filed by the petitioner under section 25O subclause 2 of the Industrial Dispute Act, and the order reads as under page 44 of extract mark. This one. The tribunal by the impugned order has directed reinstatement into original post with continuity of service, and held that the applicant is entitled for 50% back wages from the date of his suspension order dated 21/1/1995 till his date of reinstatement. ಯಾವಾಗಾಗತ್ತದು reinstatement? 31st January 2011. ಎಲ್ಲ ಕೂಡಿ ಅಷ್ಟಾಗತ್ತಾ ಅದು 10 ಲಕ್ಷ?
Now we have calculated the date of his, the closure of the factory.
That is on 15th April 2006.
But others have been paid the same thing.
It is submitted in it is submitted that the other, in light of the closure of the factory, the petitioner management is ready to pay remuneration for the period of 1st August 1996 to 15th August 2006 as is paid to the similar place workmen, and has submitted the calculation at the rate of 50% salary, coming to 6,16,024.26. The respondent is not present before the court, though served with the notice. He has the management, as the petitioner factory is being closed, and in lieu of the reinstatement and claim made by the workman would be entitled for compensation at rupees 10 lakh. And with the said observation, the petition stands disposed of, and this court passed the following order. The petition is allowed in part in lieu of the reinstatement and other benefits and 50% back wages from the date of suspension order 21/1/1995 till the April 2006. The workman is entitled for rupees 10 lakh as a compensation. Is something more than 10 lakhs? Because we will say he has been entitled for reinstatement, right? From reinstatement from 1995 till how much he would have put in service? ಅದು ಮಾಡಿದ್ರಾ? You pay another 2 lakhs. I'll say 12 lakhs.
Okay, what's our
And plus 2 lakhs anta hakoli. 2 lakhs. Yes. 12 lakhs. The petitioner pay the amount, may pay the compensation amount to the workman in 4 weeks from the date of release of this order. Yes.
I appear for the respondent in this case.
You don't come in the first hour. What should we do?
I'm sorry,
No.
my lord. Today I got held up in another court. I'm
The
sorry.
petitioner counsel is not present. You are not present. We have to simply pass.
Sorry, man. I'm ready, man. In fact, I was ready.
Ready for 5:30
Not now, my lord. Then itself I could not.
tomorrow, Monday.
Please.
All other matters pass over ಎಲ್ಲ Monday. ಅಲ್ಲ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಆಮೇಲೆ ಒಂದ್ ಏನಾದ್ರು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ 5 ಗಂಟೆಗೆ, ಆಮೇಲೆ ಕೌನ್ಸಿಲ್ ಬರ್ತಾರೆ, ನಾವ್ ಹೇಳಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. We can't. This should not be the submission of a counsel, ಅಲ್ವಾ? We record a submission, we note it, and then they say they have not made that submission. Is it proper? And this happens only after 5 o'clock. So we have decided not to take any matters at that. ಯಾವಾಗ ಯಾವ್ದು ಹೇಳಿ ಅವ್ರದ್ದು ಯಾವ ಡೇಟ್ ಬೇಕಾದ್ ಕೊಡಿ. Advocate should be fair enough to say what has actually transpired with the court. ಅಲ್ಲ ರೂಲ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು. If at all you want, if you say that we have to issue rule, it's against your interest itself, ಅಲ್ವಾ? ನೀವು ಬಂದ್ ಹೇಳಿ, we are taking up matters of whoever are coming, ಅಲ್ವಾ? Nobody is there, what should we do? ನೀವು ಬಂದೇ ಇಲ್ಲ morning. Nobody was here. And we are sitting till 5:30. Yes.